Just to make everyone who's out there aware who may be hearing me, I just started the commission's recording of this Teams meeting. And so everybody is now on camera in one form or another. We'll capture presumably the whole meeting by video, and as we get started, I'll also make that announcement. But since you all are on already, I just figured I'd go ahead and let everybody know. Nothing you need to do, just be aware.
I don't know. I've never done two in a long time like that.
See, I didn't have that on. I added this on here.
Yeah, you'd have to do it on there to see it, and they'd have to let you into that meeting.
Yeah. I got this on the phone. I can hear him. I assume it's recording.
It's recording for you. I don't think it's going to compare you to the fast and see.
EB must be another one. CF.
It's on the school again. I guess they can hear you. That's the.
Good morning, Mr. Bromer. How are you?
Not bad, Phil. How you doing?
Can't complain. Can't complain.
Okay. Oh, geez, I have no makeup on.
Well, they can't see your face. The lights are behind.
Okay.
And above you.
Oh, you're in the office.
No, that's just a face back.
Oh. You hear me, can you?
I can. Yeah.
I've got you on my phone.
All right, we'll make sure you got the button.
Morning, Mr. Norman.
I'm gonna.
Good morning, Mr.
Yeah.
I'm not seeing your handsome face, but I know you're here. Oh, there you are.
I'm here.
You're out of the basement?
I'm the only one here, so I'm not in the basement.
Ah, okay. Because I know that's your favorite place to be. Otherwise,
I think when my wife plans her official return, I may move my office up to our bedroom instead of the basement.
ah, okay. When
At least not till mid-May.
Oh, really?
Uh,
Wow. She's really digging the Florida life, huh?
Well, Andy and I are going down on the 3rd, so she decided to stay.
Ah, okay.
The only other person I see, at least as far as the commission, is Dennis. Good morning, Dennis.
Oh,
Morning,
Mr.
Scott.
Kreitz
How are you?
Mr. Kreitz is on as well.
Scott, do you have the same snow on the ground down there that we have?
Well, we did, but it was all gone by the end of the day.
Oh, you in Columbus?
I am.
Oh, I
Yeah,
thought
he
you were
was-
down in Florida.
He came back on Sunday.
I got to see the snow for the first time this year.
Yeah, we still have it on the ground here.
I mean,
Yeah, well,
I would say we had 2 inches, and then by mid-afternoon, it was all gone.
Yeah, actually, what we put some sheets over some plants, and when I took them off in the morning, they created a couple of piles next to the plants. And so when we went out to put sheets back on last night, some of that snow that was in the pile was still there. Everything else was gone, but there was some of that stuff piled there.
There's Mike. Good morning, Mike.
Good morning, all.
Ms. Fisher, we're not calling you up to the table yet, but when you do, I'm just going to ask you to step back a little bit because your face is right in the middle of the camera. Be pulled in.
Oh, that reminds me. Reminder. Connect. Yeah, that's fine.
I don't know how it was vested with this power, but it asked me to admit people. So whenever it pops up, I'm admitting people. That Phil.
Well, I'm trying to catch them so I can write them down.
You're in control then, huh, Scott?
Apparently.
Obviously, doing a better job than me. I let everybody in early. I just realized there was a memo I wanted to get to. I had to.
It sounds like what Chris is saying is I should leave it alone so he can write down who's getting in and let him bring them in.
I'm just trying to write down everybody that I see on our sign-in sheet.
I'll just leave it to you.
Oh, you're fine.
As the nominal organizer, though, I reserve the right to always admit anybody.
Hey, Catherine.
Let's see.
Good morning.
As usual, we got somebody. I just got a text from Natasha saying she's trying to get in but can't.
Well,
We
the
just-
state had a new thing that it updated this morning, I thought. So
What was updated?
I had a little challenge. Oh, just log in on Teams.
Oh, really?
Mine was.
Oh,
I use the browser
Is Don Bryce supposed to be on?
instead of going through the app.
Don Bryce, is he coming?
No. Nope. Yeah, at this point, we're waiting for Natasha and Otto. Charlita is not going to participate. She had some sort of a business-related event that she had to attend.
I just remember that because we were looking at when we needed to set the hearing and she said she couldn't be here.
Yeah. Well, I mean, I send out everything to everybody because I don't want anybody not to be informed. And I got a note back from her assistant, who I also always include on the original emails. There's Otto. She said, Charlita's not going to be there. And I said, yes, Christine, I understand. I just, always send out information to everybody because I don't want to make sure everybody's informed. She said, oh, yeah, that's what I always do too. Even if somebody says they're not going to attend. Now you know why I did it.
Phil, are we just waiting on Natasha then?
At this point, we're waiting on Natasha. Yep.
All right, that's good.
Go ahead and get started once she gets on.
Yeah.
I'm writing a message. That's
There she is.
Good morning, Natasha.
She hasn't been admitted yet.
Okay, just a few last minute things I was talking with Mr. Hughes about. Other than that, I think we're ready to go, Mr. Chairman.
All right, thank you very much, Mr. Richter. With that, I will call the April 22nd, 2021 meeting of the Ohio Elections Commission to order. If you would please call the roll, Mr.
I will
Richter.
gladly do so. Ms. Kaufman?
Here.
All right, yeah, we're able to make it in through whatever, huh? Congratulations.
Yeah.
Mr. Bromer?
Here.
Mr. Beatty?
Here.
Ms. Cunningham?
Here.
Mr. Norman?
Here.
Chair Kreitz?
Here.
All present with the exception of Ms. Tavares, who had a previous conflict to keep her away from this meeting.
All right, I'll entertain a motion that we excuse Commissioner Tavares's absence.
So moved, Brommer.
Cunningham, second.
Any discussion? All in favor of the motion signify by saying aye or raising your right hand. Aye.
Aye.
Thank you.
Motion carries. First item on the agenda this morning, ladies and gentlemen, is approval of the regular meeting minutes of April the 8th, 2021. Everyone should have received those minutes. Are there any additions or corrections to them? If not, I'll entertain a motion that we approve them.
So moved. Kaufman.
All right, we have a second. Second by Beatty. All in favor signify by saying aye or raising your right hand. Aye.
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 Opposed, same sign. Motion carries. All right, moving into hearings. The first item on the agenda this morning is Duralia versus Protect Geauga Parks et al. You'll recall this matter came on for hearing on April the 8th, 2021. Both parties were represented by counsel and presented evidence. The evidentiary phase of that hearing is now closed. The parties were asked to go ahead and submit written closing arguments and statements, I should say, by April the 19th, 2021. Those were in fact received and filed and have been shared with the commission members. Mr. Richter.
There we go. Mr. Chair, members of the commission, you obviously have the essentially what worked as the closing statements from the respective counsel on this matter. Similar to what Mr. Kreitz just said, the evidentiary proceedings of this matter have been closed. We now had the closing arguments presented to you. And so this matter should now be before you for discussion and then decision.
Thank you, Mr. Richter. All right. Anybody want to start the discussion?
I have a question for Mr. Richter. Has the statute defined what major actually is?
No, we have no, and we have had that. I don't know if I want to say we have had that specific. Well, we've addressed that issue in the past without making any kind of specific determination in terms of it's this or it's that, because it is a very fact-based determination. Certainly, the preeminent matter that we had before us that was subsequently appealed and the commission decision upheld was the the Corsi case, or the Geauga Constitutional Council case. But in that case, without getting into too many details, there were a variety of factors in terms of number of people involved, events that really dealt with politics, materials that were circulated, or I should say not just politics, but elections, materials that were circulated by the parties that that expressly advocated on behalf of or against particular candidates and or issues. And after reviewing all of that evidence, the commission determined that in that particular instance, the I can't remember, I think we determined that it was a major purpose of the group was essentially participating in the electoral system and not just merely having discussions and other events based on all of the activities involved in that particular case. Certainly what you have here before you are the arguments from respective counsel and the evidence has been presented. Excuse me, where each side laid out what it thought was, was the appropriate standard to determine. But it's a matter, I think, of each commission member assessing their belief in whether that primary or major purpose standard was established with the evidence provided.
Mr. Richter, I have a question for you. From the Ohio Secretary of State, I guess this is out of the handbook. The caption is political action committees. What is a political action committee? The pertinent line says to determine whether a purpose is a primary or major purpose, the following should be considered. And there's four bullet points that apparently someone at some point in the secretary's office decided this is an interpretation of that statute. It goes on to say when the combination of two or more persons has or will make a continuing pattern of expenditures from a common account to support or oppose any candidate, political party, legislative campaign fund, etc. I'm not going to read it all. Then the other one is when the total dollar value exceeds $100. And then the third one is when the combination of two or more persons constitute an entity that was not in existence prior to or supporting or opposing any candidate. I guess my question, because those three have a direct impact on this case, I think, what weight do we give that? Because it's apparently in the handbook.
Well, certainly the handbook is a reasonable guide and an assessment by another organization that I would say certainly has a great involvement and interest in campaign finance activities and the campaign finance statutes. I respect what is included in the handbook, but it is merely a guide. It is not the statutory. It's not statutory, quite obviously. It is merely a handbook, and it's offered as only a guide. While I'm fairly confident that everybody would like me to say, yeah, here are the specific standards in the specific outline that says what is or is not a PAC. Honestly, I don't feel like I can do that because it is a very fact-based determination. Hearing you say $100, that's an incredibly low standard to determine. At least in my opinion, it's a fairly low standard for determining whether a group is a PAC or not. I think, and again, going back to Geauga Constitutional Council, honestly, I don't remember the amount of money that was involved. But between all the various materials that were circulated and printed, holding of various events, such as even candidate nights, etc., the amount of money that was used was obviously much greater than $100, but it was also much greater than, I think it was much greater than half of the funds that the group received and organized. And so certainly that is one group's particular perspective on it. But I don't know that, and it's certainly something of a guideline, but I don't know that we are specifically held to that because it's our responsibility, the commission's responsibility, to interpret the statute and apply it as appropriate.
Other questions or comments by the commission?
This is Commissioner Cunningham. Mr. Richter, is there a statutory basis for the use of $100 in the list, and what is it, if so?
The only thing I can think of is when you look at the independent expenditure provisions, you know, that we'll get into later in this meeting. That's the one time that I can think of when that particular amount, well, there's a couple times, but that's the one particular time when it is used as kind of a determining factor on campaign finance obligations. You know, if a local group or a local PAC spends greater than $100 on a local issue, it's obligated to file an independent expenditures report. I mean, you do have, if you contribute over $100 in cash, that's a violation of the statute. That's out there as well in terms of $100. You know, but those are the two places that I can think of where that amount is specifically identified. You know, and again, even if you're talking about $100 on a local issue, that's relatively low burden, but that's what the General Assembly established. In looking at that particular statute, it goes on, I think it's even $500 on a statewide basis, which is on a statewide basis, is an incredibly low standard in terms of how much money can be expensed before you're obligated to file an independent expenditure report.
And Mr. Richter, in terms of contributions, would that contribution have to be for the purposes of the election? I mean, there are all the time corporations, lobbying groups, nonprofits who are accepting contributions that are not necessarily solicited or related to an issue or candidate's election.
I'm not clear what you're asking there. You're talking about when a corporation makes an expenditure or when a contribution is made to a PAC?
I'm sorry, I blurred that line. When a contribution is made to a PAC.
Yeah, I mean, well, you know, you're supposed to list all contributions, obviously, when a PAC receives a contribution, regardless of the amount. You know, and so whether it's $25 or $100 or, you know, $100,000, all of which PACs can, depending on how they're taking their activity, have the ability to receive. You know, you can take that money. You take that money in. You then are at least nominally a member of the PAC. I'm not sure where to go. I'm not sure exactly what you're asking, and so I'm kind of bumbling, and I apologize.
We had a lot of testimony that there were not monies solicited for the purposes of the election or advertising, that this is a nonprofit corporation that routinely takes contributions for the purpose of preserving natural environments.
Right.
And
Yes.
that organization is a 501c4. There isn't a tax deduction for it, and that they took their own funds and spent money for a political advertisement. So, you know, when I think of a PAC, I agree with you that if you receive a contribution for the purposes of an issue in election, you absolutely are a PAC and have to report it. But I'm struggling with the, how do we distinguish between an existing organization that routinely has funds and chooses to spend their funds one time one way or two times one way versus a PAC who's formed for a purpose, soliciting funds for that purpose and spending for that purpose. It's difficult. I mean, I understand that it's a facts and circumstances question, but I'm not sure how you answer the question as a PAC when there weren't funds solicited for a political purpose, or at least there's no evidence that there was, as I recall, and I welcome other people's input on that.
That was my recollection as well, Ms. Cunningham.
Yeah, well, and I think too, yeah, it's a matter of, I'll keep going back to Corsi and the Geauga Constitutional Council, because it's the one time where we made a more definitive statement than we have at other times. when you looked at the money that it took in, that Mr. Corsi tried to explain off as, well, you know, we do many other things than endorse candidates. But then when you looked at what they did at the meetings that they held, what the materials that they circulated, you know, when you looked at all those factors and assessed the money that they brought in, again, it was, as my recollection, it was much greater than half of the total amounts that they received, and they used toward actual express advocacy. You know, here, I think there was over $100,000 that was, you know, thrown out as a stab, or as accumulated over time, and about $6,000 was expended during this particular period of time. And certainly the complainant placed a great number of web pages and so forth before the commission. But my recollection is there was also an incredible list of other events that they undertook in terms of conservation, parks, etc., that didn't have any mention of political events or electoral events included in what they, you know, and what they were doing. And so it's a matter of, you know, not only just assessing the times when they did engage themselves, as they admittedly did, but what other things and what other, you know, in this particular context, what other park-related and conservation-related events were they conducting at the same time or during the entire period of time? And when you assess all that compared with their actual active electoral activities, is it greater than a majority, or is it their primary purpose? And so that's essentially what you're trying to assess in looking at all of the information provided, and, you know, and to a degree, not just what occurred between, I guess you'd say, what was it, December and April of of 2020, and even going back to other times when they did certain things. And, you know, the other thing was it was included in their that they came down and lobbied the legislature and did other things. Well, I mean, you know, certainly a PAC could do that, but that doesn't necessarily, in my own humble opinion, that doesn't necessarily make any organization a PAC if you are lobbying the legislature. If you are doing other things like that, because that's not per se electoral related. It's not endorsing or opposing a particular candidate or issue. It's talking about issues, even if it is talking about a particular person. Those are, to me at least, those are separate and distinct things from an electoral nature.
And would endorsing or opposing a candidate or an issue in and of itself make an organization a PAC?
I'd say in and of itself, no, because, you know, while I guess what I could say is prior to Citizens United, you'd probably be inclined to say yes. But after the decision made by the Supreme Court, corporations now, as long as they're doing so independently, have an ability to participate in the electoral system here in Ohio, no different than they do across the United States, because of that decision. And that certainly, you know, allows a broader extent of persons to involve themselves in the system than just political action committees.
My struggle is again, the statutory definition of major purpose, because if they had wanted to say a majority of their purpose, they could have. And so you could have immeasurable number of major purposes. And if one of
you're breaking up, Mr. Norman. You were breaking up, so we couldn't hear all of that.
I said my struggle is with the term major. It's not majority, it's a major purpose, and they could have many major purposes, one of which could be to affect the election or the outcome of an election.
I can't disagree with you, and that's correct. Boy, I wish I could, I'm not sure that I can call up an old version of the PAC definition. Not that the current one is that good, but it was changed any number of years ago to go to a primary or major purpose standard. When prior to that, it was, let's just say, different at this point.
Well, you know, much of the activity that we're talking about here is certainly permissible as a 501c4. And I don't think we're about to say that every entity that's a 501c4 that goes ahead and advocates and lobbies is a PAC. I mean, what, Phil, as I understand it, the burden of proof here is by preponderance of the evidence, right? I mean, in order for us to find a PAC by preponderance of the evidence, we have to find that what we're talking about is the primary or major purpose of the entity, correct?
Correct. Yes.
All right. Well, you know, I'll kick it off here then. I take a look at this and, you know, I understand the arguments on both sides, but I find it, you know, I don't believe that it's been established by preponderance of the evidence that the primary or major purpose of this entity was to support or oppose candidates, political parties, etc. Certainly there's evidence, and I'm not disputing that. Much of that evidence is clearly permissible as a 501c4. I mean, we're almost talking a freedom of speech issue here, I think, and I think it's really important that we understand that entities such as this have the right to go ahead and do that without becoming a PAC. So I'm not convinced, based upon my assessment of the evidence, the testimony, the exhibits that were admitted, that there's been an establishment by preponderance of the evidence that this was a primary or major purpose of the entity.
Well, I guess I'll go next, and I'd like to say one thing I found interesting was in the closing argument from Project Geauga Parks. It said Project Geauga Parks was created as, and this is a quote, as a result of Judge Grendel changing the mission of the Geauga Parks District, thus giving rise to the creation of Project Geauga Parks. And I think at the hearing, we heard an awful lot of information and facts that they really, from 2014 on, did everything they could to get Judge Grendel out of there. Now, it gets tricky, and I agree. They can also show they do other work, and I'd like to applaud them for the other work they do. But I am having a hard time seeing how they, from 2014, engaged in conduct that truly was meant to oust this particular judge. And that's my problem with this.
See, I don't think there's any question, Dennis, that in fact did occur. And certainly that was made loud and clear to the commission as a result of the testimony. But I also found, by taking a look at the mission statement and some of the other exhibits that were admitted into evidence, that there were a lot of other activities that were going on here. And again, just because that was an important part of their mission doesn't mean that they've proven that it's been established by preponderance of the evidence that that was their primary or major purpose. I mean, the burden is on the complainant here to establish by preponderance of the evidence that, you know, that was a primary or main purpose. And I don't think they've accomplished that.
And I would agree with you, Mr. Chairman. I think there was evidence that they were engaged in other activities. I guess what I would like to know, maybe from you, Phil, when would it cross the line? When would it become, when would it cross the line from, if, for instance, if they were supporting two candidates, would that cross the line? Would that mean they're not fulfilling their major purpose anymore?
Not necessarily. No, I don't think the number of candidates involved, comes into, to me at least, I don't think the number of candidates involved becomes a deciding factor. You could have as many candidates as you wished if they felt like it was protecting the parks, and they wanted to say this legislator or that legislator or this city council person should be elected during the electoral season. Certainly they seem to have focused here on one particular candidate. It could be they spend more time on this one particular candidate than they would if they were to be involved in a variety of races. See, Mr. Norman must have disappeared and come back. So I don't, the number of candidates I don't think really would affect it. I think it's a matter, again, of assessing all of the various functions that a particular organization does and looking at that looking at that as a comparison to how much time they involved and invested, along with how much money they invested in taking actual express advocacy and political participation. Because really, to be a PAC, you have to involve yourself in express advocacy. Just merely, saying, we think it's important to vote, isn't really express advocacy. You're not expressing for or against any particular candidate, but certainly voting is something that an organization can be very interested in doing, but that doesn't necessarily make them a PAC.
Well, I think the evidence showed that they did a little bit more than just say, try to get people to vote. And my only concern is this a means for another organization to try to affect the outcome of an election and simply say, well, that's not our major responsibility? That's what bothers me about this case.
Other commission members?
I would have to agree with our chair that the primary purpose is not to advocate for or against. I think it was secondary. I think that we did not see the scope of the other things that they've done. We saw an example from their website of different events that were held, but I don't think that shows us the full scope of the things that they do in their advocacy of protecting the parks. So to me, I don't think it's been proven that they were a PAC. I think it's a very, very gray, blurred line area, but I don't think it's been proven beyond a shadow of a doubt that that's what they set out to do. I think that the good that they're doing maybe has been diminished because of the other things that have been brought to light as opposed, as opposing Judge Grandel. So.
Other commission members?
I'm going to say at this point, Mr. Hughes and I have been conversing. We don't think Mr. Norman is currently in the meeting. He was in, then he was out. I thought I let him back in, which we both did.
Let's take a second here to make
Yeah,
sure
but
he gets back in.
He doesn't appear to be in right at the moment.
I have no additional comments on the issue.
Thanks, Otto.
If you're waiting for other people to speak up.
Yeah. I was also waiting to see if we could get Mr. Norman back in so that he participates fully in the discussion. Mr. Richter, are you reaching out to him by text possibly?
That's what I was just about to do.
Okay, thank you.
You out there? Okay, all right. Okay, we'll look for you because we kind of halted. We noticed you were gone, and so we halted. So, okay, bye. Oh, I interrupted him trying to get back in.
Okay, we'll just wait till he gets back in then.
He was gonna call to participate because he said for some reason his computer was keeping him out. All right, I'm out looking at something else. If you would keep an eye on him, Chris.
Okay.
Is that him? Okay.
Hi, this is Scott Norman. I'm back in the meeting, at least by way of telephone. I'll keep trying to get my video up.
Okay, yep, that's you. Okay.
Thank
Welcome back,
you.
Mr. Norman.
Okay, we're at the stage where each of the board members have been given an opportunity to share their thoughts. Any other discussion, or do we have a motion?
Ms. Kaufman, in case Mr. Norman missed it, would you want to repeat some of what you just said, just for his edification?
My belief, I agree with Chair Kreitz that I believe the primary purpose of Protect Geauga Parks is to conserve or preserve the parks. I feel like secondary became the removal of Judge Grendel because that's their opinion that his behavior is harmful to the parks. But I don't believe it's been proven that that was their main purpose, was to advocate against him. I believe that their good works that they've done was not fully seen the scope of it by us because we had such a small snippet of what we were able to see of the things that they do, the events that they hold. And I think that their primary purpose is really to protect the park. So that was my contribution.
Okay, thank you.
Thank you. All right, any other questions, any other thoughts, any other discussion? If not, then I would entertain a motion if there is one to be made. First time this commission's been that quiet since I've been on. Do we have a motion? How would you like to proceed if you don't want to make a motion, ladies and gentlemen?
So I guess if I'm approaching it one way and I think there's no violation, is to just move to find no violation?
Yes.
I would move that we find no violation. This is Commissioner Norman.
All right, Commissioner Norman, thank you. Do we have a second to that motion?
Second, Beatty.
Thank you, Mr. Beatty. Further discussion on the motion to find no violation? If not, all in favor of the motion signify by saying aye or raising your right hand. Aye.
Aye.
Opposed, same sign.
Aye.
All right.
That
Record
motion passes 6-1 with Mr. Bromer voting no.
It should be 5
That
to
would be
1.
5 to
Or
1.
5
5
to
to
1,
1.
you're right. I know how to count.
That's all right. That's fine. All right, motion passes by a vote of 5 to 1. Again, I think both of the parties and their counsel are on. Thank you very much for your arguing of the case. We very much appreciate it, and we wish you the very best. Moving on to the next item on the agenda would be discussion and approval of written decision and finding in case numbers 2019 R-318, 2020 R-057, 2020 R-058, and 2020 R-059 consolidated. Cuyahoga County Board of Elections versus Elkins et al. We should have all received what I think Phil alluded to as his final draft of that decision. Mr. Richter, do you have any comments before I go to the commission?
No, not anything further than what I've done. If there's any other corrections or any other additions that someone would like to add, certainly we can always incorporate that. But, you know, after hearing comments from other people, making adjustments and adding additional items as time has gone on, I think it properly reflects the essential finding that the commission, you know, made, and simply saying there was a violation. I think this puts into words the extent of the commission's finding in this case. And so, I think I've done what the commission wanted me to do. If there's any other comments, certainly we can adjust and make changes. Other than that, I'd say it's a matter of, approving it, and then considering I have it as a signatory for Mr. Kreitz, approving, authorizing Mr. Kreitz to sign on behalf of the commission.
Thank you, Mr. Richter. Questions or comments by the board? If not, I'll entertain a motion that we approve the written decision and findings in this case.
This is
Cunningham,
Commissioner
so
Norman, I
moved.
move.
All right, we have a motion by Commissioner Cunningham. Second?
Second, Norman.
Second by Mr. Norman. Further discussion on the approval of the decision?
Just Phil, sorry, I should
No,
have told you,
problem.
there's a typo on page 4, 4 lines up from the bottom. STATES should not be plural. That's all. It's technical, but you see that when you read it and it sticks out.
Thank you, Ms.
Do my
Cunningham.
best. Well, I got to give Mr. Hughes some credit for his good eye on other things. He didn't look at this one in advance, so that's my fault for not getting him to look at it in advance.
Well, and have him look at it again and if there's anything else, but that's the only one I saw.
Okay.
Do we have to approve Mr. Kreitz to sign it, or just approving it is enough?
I generally in the past, what we've done is essentially authorize the chair to sign on behalf of the commission. Yes.
Okay.
I can amend my motion accordingly if Mr. Norman agrees.
Absolutely.
All right. All right, any other discussion? All in favor of the motion signify by saying aye and raising your right hand.
Aye.
Opposed, same sign. Motion carries 6-0. Thank you very much.
Very good.
Thank you, Phil, for drafting that. Well done.
No, not a problem.
And Ms. Cunningham, thank you for your amendments and revisions. All right, moving on to preliminary reviews. The first case is case 2019 D-014, Thaxton versus Fisher. Mr. Richter?
I will remind everyone that this matter was actually fully addressed on March 25th. The commission then held final determination on the matter until today. The evidence, no decision was made on whether a violation had occurred or not. I was directed to do some additional research and present something to the commission. I provided everyone with a memo concerning the findings that I made as I looked at this complaint, the circumstances, and the statutory provisions. And so I circulated that to everybody. And so now it's time to decide the particular case, obviously. Based on my additional research, the memo that I presented, and you can see the working agenda today, my recommendation would be to find no violation. I'm certainly willing to answer any other questions that the commission may have.
Thank you, Mr. Richter. Questions of Mr. Richter and or his recommendation? If not, I'll entertain a motion.
Commissioner Norman, move to find no violation.
All right, motion to find no violation. Do we have a second?
Second, Commissioner Brammer.
Second by Mr. Bromer. Further discussion? If not, all in favor signify by saying aye or raise your right hand.
Aye.
Aye.
Opposed, same sign. Motion carries 6-0. Thank you very much.
Thank you, Ms. Fisher.
Ms. Fisher, thank you very much. Moving on to the next preliminary review, it is case number 2021 G-001, Purdy versus Simeon. Mr. Richter?
This case, the complainant asserts that the respondent has not filed complete and accurate campaign finance reports, withheld certain campaign account information for their local PAC, for which the complainant is now responsible. I guess I should say. I think a subsequent designation of treasurer has been filed, so she's treasurer. We have received a response from counsel For the respondent, we have received a response from the respondent himself, an affidavit from the respondent, all of which has been provided to you. In addition, there was a response from the county party chair as it relates to the circumstances. I believe Ms. Purdy is present. The complainant is here present, and counsel for Mr. Simeon, Ms. Mack, is present if the commission would want to hear from those persons. I am spotlighting Ms. Purdy if the commission would want to hear further from her.
Good morning, Ms. Purdy.
She's muted.
Ms. Purdy, you're muted. You need to unmute yourself if you wish to speak to the commission.
We'd also like if you put up your video for us as well.
Yeah.
If you go to the upper right-hand portion of your screen, there's a video and there's also a microphone. If you click on both of those, it'll open them both.
Okay. Ms. Purdy, are you there? It doesn't appear that you are muted anymore. Ms. Purdy, can you hear us? Are you wanting to address the commission?
Can I make a suggestion? Maybe moved on to agenda item number 3 until she figures out and come back to this, since she's here.
Oh, she just muted herself again. Can't disagree with that approach. All right, well, Ms. Purdy, are you there? Can you hear us and can you speak to us?
All right.
All right. Okay, we'll delay on that one and move on to case number 3, T-Meyer versus Begtrip, 2021 G002. This case involves the complainant asserts that the respondent has not filed a complete and accurate campaign finance report. Primarily, one particular expenditure was missing. The treasurer for the respondent's campaign committee responded, indicating primarily that the billing was not received until January and therefore was not included on the post-election report because it had not been received. I have not seen in Mr. Hughes, has anybody indicated that they're here for that particular case?
I don't have anybody on.
Yeah, I mean, I haven't seen any of those names appear in terms of, present as a part of the meeting. So I don't, is there anyone present here on behalf, either the complainant or respondent in 2021 G-002 T-Meyer v. Begtrip? Okay, who?
Clark.
So this is Chad Clark for the Begtrip campaign.
Oh, okay, Mr. Clark. All right. Yeah, and you did submit a response. I have it. I didn't recognize. I was looking for Begtrip and not necessarily you. Okay. Is Mr. T-Meyer there? Or is anyone here on behalf of the complainant? Okay. Presumably then there is no one here on behalf of the complainant. We have the complaint, you have the response. We could certainly hear from Mr. Clark. Based on the materials that were presented to me, my recommendation is to find no violation. Certainly if the commission wanted to hear further from Mr. Clark, I could have him sworn and the commission could hear from him further.
Mr. Clark, thank you very much for being here this morning. Did you understand what Mr. Richter said? His recommendation is that there be a finding of no violation. You certainly have the right to be sworn and testify if you would like to. What is your pleasure?
Sir, I think I'll let it stand.
Okay. Well, we're not trying to talk you out of it. I mean, if you want to have your moment of glory, you certainly can have it, sir. But I understand. All right. So my understanding is Mr. Clark is choosing to stand on the evidence as it's already been put forth in the record. So we have a recommendation of the executive director that in case 2021 2021G-002 that we find no violation. Is there a motion to that effect?
So moved, Kaufman.
Thank you. We have a second?
Second, Beatty.
Thank you, Mr. Beatty. Any discussion on the motion to find no violation? All in favor of the motion signify by saying aye and raising your right hand.
Aye.
Opposed, same sign. Motion carries. We found no violation. And Mr. Clark, thank you very much for being here this morning. You were particularly articulate. I want you to know that. You carried the day. So thank you very much, though, for being here.
Thank you very much.
Okay, take care. All right, Phil, before I move on to reconsiderations, any further word on Purdy versus Simeon?
I don't at this point. I'm going to recommend, let's go and take care of the reconsideration matters just to get them out of the way, because those should be fairly quick.
Okay, case number 2015 R-069, Ethan Reynolds et al.
And I believe Mr. Reynolds is present. Mr. Hughes just highlighted him for the commission. If you would like to hear further from him, we received a request to have the matter reconsidered. I have placed it before the commission. And I synopsized it for the commission's consideration. Mr. Reynolds has paid a substantial amount on fines imposed by the commission in a prior case. He's in a situation now where the board no longer has information for him that would allow him a certain ability to clear up and deal with his reports. And so based on all the circumstances, my recommendation to the commission is to reconsider the matter, vacate the previous imposition of the per diem fine, and instead impose a fine in the amount of the payments already made by Mr. Reynolds, which amounts to approximately $8,400. But then also to declare the committee terminated so that there's no more filing obligations. If the commission would like to hear further from Mr. Reynolds, I could swear him in to make an additional statement.
Mr. Reynolds, would you like to make a statement this morning, sir?
No, if I don't have to, no.
Okay, no.
Thank you.
Thank you very much. All right, questions, comments, motions by the commission with respect to this case? We have a motion to follow the executive director's recommendation.
So moved, Brommer.
Thank you, Mr. Brommer. Do we have a second?
Second, Cunningham.
All right, thank you, Ms. Cunningham. Is there any further discussion on the motion to accept the recommendation of the executive director as set forth? If not, all in favor of the motion signify by saying aye or raising your right hand, or both.
Aye.
Aye. Opposed, same sign. Motion carries by a vote of 6-0. Thank you again, Mr. Reynolds. Appreciate you being here this morning.
Thank you, guys.
All right, take care of yourself and good luck, sir.
Thank you.
Second reconsideration matter, case 2019 R-474, Brenda Fry et al. Mr. Executive Director.
Yeah, you've seen my synopsis of the case. Ms. Fry filed a termination report in the annual filing period most recently after receiving notice from the commission that she was outstanding. She's terminated her committee, asked for reconsideration. So I'm recommending the commission reconsider the matter, vacate the previous imposition of the per diem fine, and instead impose a fine of $100. I do not believe Ms. Fry is present in the meeting today. She has been notified. Ms. Fry, are you out there? Is someone out there for Ms. Fry in case number 2019 R-474? If not, then you have my recommendation before you.
All right, thank you very much, Mr. Richter. Questions, comments by the commission? If not, I'll entertain a motion that we follow the recommendation of the executive director.
So moved, Brommer.
Thank you, Mr. Brommer. Do we have a second?
Second, Kaufman.
Thank you, Ms. Kaufman. Further discussion on the motion to follow the recommendation of the executive director in this case? If not, all in favor signify by saying aye. Raise your right hand.
Aye.
Opposed, same sign. Motion carries by a vote of 6-0. All right, thank you.
I did see that Ms. Purdy just tried to get in, and I'm assuming she was admitted by Chris.
Yes,
Is she?
I am showing she is back in the meeting.
All right, did we want to go ahead and call that case one more time then? Purdy versus Simeon et al., case 2021 G-001?
I would think so. Chris, can you highlight her? Because you may find her easier than me.
Just,
Okay.
Ms. Purdy?
Ms. Purdy, are you there? Can you hear us?
There she
Now
is.
you see her.
Good morning, Ms. Purdy. Can you hear us?
Well, yeah, I guess that's something. We can now see you, Ms. Purdy, but we still can't hear you. And there's nothing on our end that I can think of as keeping you from addressing the commission.
She looks like she's frozen to me.
She moves
She
bits and
moves from
pieces
me.
here and there.
Yeah.
Yeah.
All right, can we keep trying to get hold, maybe making contact with Ms. Purdy, but let's go ahead and move on to the next preliminary review while we're waiting.
Okay.
All right, case 2020 R-379er, Bud Hanchin et al. Go ahead.
Bear with me for 1 second as I note. Mr. Chair, members of the commission, this is a complaint from the Wood County Board of Elections asserting that the respondent did not properly file a full and complete campaign finance report under revised code section 3517-105, the independent expenditures filing statement. Mr. Hanchin bought, among other things, a billboard, I think some other materials. Some other materials in opposition to a school ballot issue in his community. The reports were filed anonymously on his behalf, but they did not disclose him as the statute would require. Subsequent, then we had the referral from the board. You've received an affidavit from Mr. Hanchin explaining the facts and circumstances from his perspective. He is represented by counsel, Derek Klinger, from the McTighe Law Office. And certainly if the commission would like to hear further from Mr. Klinger on this case.
Okay. Good morning, Mr. Klinger.
Can we change the highlight to Mr. Klinger as opposed to Mr. Hanchin?
There we go. Thank you very much.
I mean, like that?
Derek, can you hear us?
Yes, thank you.
Okay, very good. Mr. Richter, I just want to confirm that there's nobody here on behalf of the Wood County Board of Elections.
Yeah, well, let's see. Is there anyone, I guess I'll make that announcement as we are here. Is anyone here on behalf of the and would like to speak on behalf of the Wood County Board of Elections? Because I was informed, I think at some point yesterday, that the attorney from the prosecutor's office who did a lot of work on this and assisted the board in preparing this and sending the matter down to us was not going to appear at the hearing today. And so I was given that information. As I indicate, I responded back to her and said that, you know, certainly the complaint speaks for itself and can speak for itself. And so it doesn't appear that anyone is here on behalf of the Wood County Board. And so we certainly can hear from Mr. Klinger if that's the commission's preference.
All right. Well, thank you very much. Mr. Klinger, why don't you go ahead and make a statement if you want on behalf of your client?
Yes, thank you, Mr. Chairman, members of the commission. Again, I'm Derek Klinger on behalf of respondent Bud Hanchin. As you saw, Mr. Hanchin is also with us today on the meeting. If you have any questions for him, he is available to answer those. Now, as Mr. Richter alluded to, this case concerns allegations of Mr. Hanchin filed incomplete independent expenditure reports in connection with a school levy in 2019 and a school levy in 2020. Specifically, the allegation is that Mr. Henshin failed to include his name on the reports. And I'll come back to this in a few moments, but just keep this in mind. What Mr. Henshin did is he did file on time independent expenditure reports in connection with both elections. He disclosed the expenditures, the recipient of the expenditures, the amount of the expenditures, the dates of the expenditures. He also identified the elections that they were in connection with, which are the statutorily required information. And then in the name field, which is a requirement, which is just a field that's been added by the Secretary of State. In the name field, Mr. Henshin wrote individual DBA polling and levy facts. And then that's on the 2019 report. And then on the second report, he wrote unnamed individual. Now, I'll explain why he did that in just a moment. Again, as Mr. Richter stated, Mr. Henshin did file an affidavit with you all, and we've also filed a motion to find no violation, or alternatively, if the commission does find a violation, a motion to find good cause not to impose a fine. Now, I won't repeat everything that's in those filings, but I do want to note a few key facts. Mr. Henshin began making expenditures in connection with his school levies back in 2017. What happened then is he decided he wanted to make or pay for mailing out to all the voters. And prior to making that mailing, he actually spoke to the Board of Elections director and talked to him about this. At that time, it was 2017, the Board of Elections director told him that if he was going to do this as a political action committee, that Mr. Henshin would need to file reports on behalf of the PAC, but that if he was going to do this as an individual, spending only his personal funds and not acting with anybody else, that he didn't have to file any reports. So Mr. Henshin relied upon this in 2017, made those expenditures, independent expenditures, did not file any reports with the Board of Elections. Board of Elections never contacted him about this, so he, in his mind, that what he did was complying with the law because he complied with what the Board of Elections director had told him. Now, another levy was submitted in 2018. At this point, Mr. Henshin participated in the election as part of a political action committee this time. And this political action committee disclosed all the contributors, including Mr. Henshin, who had made in-kind contributions. The result was a newspaper article about everybody who had participated with the political action committee, including Mr. Henshin. Now, as a result of this newspaper article and the publication of his involvement, Mr. Henshin and the others involved with the PAC started receiving harassing letters. They were threatened, their families were threatened, their property was threatened. We've included with the affidavit one of the hate letters that Mr. Henshin received using colorful language. It called Mr. Henshin the asshole of the year, and said that when Mr. Henshin dies, people are going to visit his grave to piss on it, is what the letter said. So this experience left Mr. Henshin understandably upset. He did not want these threats. He didn't want these sort of hate messages directed at him. He's a member of the community. He's also a business owner. And so he had concerns. Now, I'll also note that in this newspaper article, the Board of Elections director was again quoted as saying political action committees have to file reports, but that individuals acting alone do not have to file reports. So this is now the second time the director has said that individuals acting alone to make independent expenditures do not have to file anything with the Board of Elections. Now, fast forward to 2019, another levy has been submitted. Mr. Henshin wants to get involved again, but based on his experience in 2018, where he received all of these hateful messages, these threats, these reprisals, based on that experience, he decided he was going to do this independently on his own. Again, he once again spoke with the Board of Elections director, ran this by him, explained it again, and once again, the Board of Elections director told him, no, if you're going to act as an individual, no reporting requirements. You can do it anonymously. So that's what Mr. Henshin did. He entered into contracts to do billboards. He also paid for a newspaper article or newspaper advertisements. In reliance upon this advice from the director that he does not have to file anything. Subsequent to the election, after these expenditures are made, the Board of Elections director then contacts Mr. Henshin and says, okay, you know, all those times I told you didn't have to file reports, I was wrong. You do have to file something. You have to file this independent expenditure report, which the director was clearly not familiar with. Again, he previously twice told Mr. Henshin that he didn't have to file these reports, and on another occasion to the newspaper said he didn't have to file anything. So Mr. Henshin was understandably very annoyed, very upset by this. He had been told that he doesn't have to file anything and that he can participate anonymously. And then after he relied upon this, the director then comes back and says, actually, you know, you do have to file this. So what Mr. Henshin did at this point was he sought legal counsel to try to understand what his obligations are. Now, to preserve his First Amendment right to anonymous political speech, what Mr. Henshin did was he filed an independent expenditure report, as I described earlier, in which he disclosed the expenditures, including the dates of the expenditures, the amount of the expenditures, and the issue that they were made in connection with. But then in the name field, he wrote again, individual DBA Bowling Green levy facts. That was the 2019 report, and then he did the same thing in connection with the 2020 election. That report, again, he wrote unnamed individual in the name field, but then again disclosed all the required information about the expenditures. Now, both of those reports were accompanied by cover letters from his legal counsel explaining these reports, saying that they were being filed on behalf of a client who wished to preserve his First Amendment right to anonymous political speech, and that if the board had any questions about what was being done, that they could contact the legal counsel. Now, importantly, the board never attempted to contact legal counsel. Instead, they, as set forth in the affidavit, they launched a pretty over-the-top investigation, including issuing subpoenas to try to figure out who had made these, who was behind the report, really. Now, after learning of the referral that was filed with the commission, Mr. Henshin went ahead and voluntarily filed amended reports listing his name and address on those reports. So those are the key facts. And again, we're requesting first and primarily that the commission find no violation today. And the main reason for that is because Mr. Henshin has actually, again, kindly filed amended reports, including the information that was alleged to have been missing. The reason we're asking to find no violation is that the law, Ohio Revised Code, and I've cited this provision in our motion, RC 3517.11B3A, it actually creates a grace period for campaign finance filers, where if you file a report, the Elections Commission, I'm sorry, not the Elections Commission, the Board of Elections has to accept that report on a conditional basis. And then at this point, the board needs to conduct its review of the report. And if it finds or determines that it's missing information, at that point, the Board of Elections is statutorily required to contact the filer saying, hey, you're missing information. And at that point, that triggers a 21-day period in which the filer is allowed to file an amended report to correct the missing information. Now, if the filer fails to respond to that letter, or if they don't provide the complete information that's requested, only at that point can the Board of Elections then send a referral to the Elections Commission. Now here, again, Mr. Henshin or his counsel never received any sort of audit letter from the Board of Elections. So this grace period never ended under the statute. So it never expired. And then upon learning of the referral, Mr. Henshin went ahead and voluntarily filed amended reports. So based on the law, which again creates this grace period, Mr. Henshin has complied with it by amending his report prior to the expiration of anything. So for that, then we're asking that the commission find no violation. Now, we did raise a procedural argument saying that this should be dismissed for the additional and related reason that the board having to provide notice to Mr. Henshin is a reason an additional reason to dismiss the complaint. I would like to withdraw that argument. It's basically a moot point. If you find no violation, then you don't need to really address this argument. I am withdrawing that procedural argument. Additionally, you can find no violation for the additional reason that the name requirement for independent expenditure report is actually not in the statute. What the statute says is that they need to disclose the date of the expenditure, the amount of the expenditure, and the election that the expenditure is made in connection with. Now, it says that the Secretary of State can put all of this in a form, and what has happened here is that the Secretary of State created the form and added the name requirement. But at that point, it's a Secretary of State made regulation, it's not a statutory requirement. So based on this, Mr. Hentgen has complied with the statute as written, but this also just brings us back. It really doesn't matter because ultimately, Mr. Hentgen timely amended his report consistent with Ohio law. So for these reasons, you can find no violation. Now, in the argument, we've also made constitutional arguments saying that the law is unconstitutional under the First Amendment on its face, and then also as applied to Mr. Hentgen. I understand and respect that the commission has no authority to declare a law unconstitutional, and you have to apply it for what it is. I'm noting this because we are preserving our argument to challenge the constitutionality of these laws down the road, potentially. But we are not withdrawing that, and I will not make the constitutional argument since you have no authority to declare it unconstitutional. Now, finally, if the commission disagrees and it finds a violation here, we respectfully request that the commission find good cause not to impose a fine or any sort of penalty. There's really three key reasons for that. First, again, and all these key reasons really relate to Mr. Hentgen's good faith effort here to comply with the law. And these three key reasons are, first, he, again, repeatedly reached out to the Board of Elections director and trying to understand the law, and the Board of Elections director kept telling him, no, you don't have any reporting requirements. And Mr. Hentgen relied upon this, and then only after the fact, after he had made these expenditures, the Board of Elections director then said he was wrong and that he had to correct it. So Mr. Hentgen kind of relied upon this to his detriment, and for that reason, we would ask that you find no penalty here. Additionally, Mr. Hentgen again did timely file the reports in the first instance. They're all timely filed by the deadlines. It was not a complete failure to file anything. And third, again, Mr. Hentgen has voluntarily amended the report. So even if you find that Mr. Hentgen was required to have disclosed his name in the first instance, he has brought himself into compliance on his own volition. So to conclude, we're asking that you find no violation, primarily because Mr. Hentgen amended his report consistent with the grace period set forth in the Ohio Revised Code. But alternatively, if the commission finds a violation, we respectfully request that you find good not to impose a fine or any penalty. Thank you. With that, I'd be happy to take any questions.
Thank you, Mr. Klinger. Questions of council by the commission or Mr. Richter? All right.
This is Commissioner Cunningham. I do have one question. Mr. Klinger, I'm struggling with your argument that when the statute says an individual shall file a statement, that they don't have to disclose who they are. I mean, that's what the statute says. You're telling me that the statute doesn't require him to identify himself, and I'm really struggling with that interpretation. Can you explain to me why you think an individual can be required to make a statement but not say who they are?
I can hear the meeting.
I think that might be Ms. Purdy. If you can mute yourself until it's your.
All right, thank you.
Yeah, thank you for the question, Commissioner Cunningham. Yeah, so I'm relying on the statutory language, which says that you have to file a statement itemizing all independent expenditures made during the period. There's no requirement that you disclose the identity that some Secretary of State has added.
Excuse me, Mr. Klinger.
I wouldn't mess with anything that involves area. And hopefully once this case is over, they can have you just click the camera on and off. And
That's Mr. Hughes talking to Ms. Purdy. We're trying to help her get in right at the moment, and she's not muted there, and that's what we're hearing.
All right.
I'm interested in Mr. Klinger's response because I have something I'd like to say to that as well, Ms. Cunningham.
All right.
Should we take a 5-minute recess? So Chris.
Ms. Klinger response. So I can hear all of this. I see myself in the bottom right, and I'm ready.
Thank you for your patience, Mr. Klinger.
Can you see me, Chris?
Mr. Chair, I recommend, I follow Mr. Norman's recommendation that we take a 5-minute recess.
Let's take a 5-minute break. It's 11:15 now. Let's be back at 11:20, and maybe we can get everything else resolved.
Okay.
Thank you, Mr. Klinger.
Thank you.
Yeah, we want to be able to hear you.
Yeah, Ms. Purdy, are you there now?
Hi,
Okay.
I am.
All right.
Can you hear
Well,
me
now
through
just-
the laptop?
Right now, I can hear you right now. We were dealing with another case when you kind of came in there. I know it's not your problem, as it were. But I'm not.
Well, is
I'm
he
gonna
hearing
tell
me through my cell phone? Or
No, I'm hearing you through my computer. I'm hearing you through the Teams setup right at the moment.
Thanks,
I
Chris.
can see you.
Okay.
And so I'm not going to, considering the issues we've had, bear with me. I'm not going to tell you to mute yourself at this point, okay? Because I'd hate to think of you muting and then having a problem unmuting yourself when time came. But we're on a 5-minute break right at the moment. We're going to finish up with this other case that we're dealing
Yes, I
with.
heard that.
And then we'll come back to you, at that time. So what I'd say is just, hang tight, sit on the sides, don't mute yourself, but be quiet. We'll finish with the other matter that we're currently dealing with, and then we'll take up your case and hear from you at that time, okay?
Okay, thank you so much. And I apologize for this technology.
Well, no, you never know what, we've had other issues at other times, so we're, those kind of things can happen when you're trying to have a meeting like this, but it is what it is, so we'll deal with it. So just I'll ask you to be patient with us and let us deal with the other matter that we're currently dealing with when we come back.
That's fine.
Thank you very much.
That's fine. No, thank you. I appreciate it.
Mr. Richter?
Chris, I don't know if you're there, but there's a guest waiting to come in named Kathleen.
Yes, I just admitted her. Mr. Richter will be back in just a moment. He ran down to the vending machine to get a pop.
Okay, we'll wait for him and then we'll go ahead and get started.
Seems like we're having more than just one technical.
Can you
issue
still hear
tonight.
me?
I heard someone.
That's Kathleen Purdy.
Okay, Ms. Purdy, this is the chair of the commission. We're going to go ahead and conclude the hearing that we have currently ongoing at this time. And once we've completed that, then we'll go ahead and come back and take your case, ma'am. All right?
Thank you. I certainly appreciate it, Mr. Chairman.
Not a problem. Thank you very much. Mr. Richter, I want to confirm that we have our 6 board members back.
I believe that to be the case. I apologize if I held things up. I think
All right.
I'm sorry.
I believe we have everybody back.
Chris is saying he's not sure if he sees Mr. Beatty. Is Mr. Beatty present? He sees an empty chair.
stepped
I'm
out,
not,
looked like.
yeah, so Otto may not be back yet.
Okay.
He was here during most of the duration of the break.
Right.
Derek, are you at home or are you at the office?
I'm at home.
You said German Village? It looks like German Village molding. That's why I was asking.
Marion Village, so I'm just south of German Village.
Okay. All right.
Good read.
He lived there for a while, Derek.
Gotcha.
I don't really think there's a distinction from being at the office and being at home myself. Just saying.
All right. Is Mr. Beatty out yet?
No.
Okay.
I see the picture in his empty chair.
I'm glad you can see it because I'm not calling him up, but I don't see anything on him.
I don't either. We'll
Oh,
wait a few
I
more
see
minutes.
certain people, but his picture is just part of my gallery and he's not in his chair.
Okay, yeah,
His
Chris
door-
has his on. I don't have it on gallery. I've got just Derek highlighted. Chris has his, and so Chris will be able to see. Oh, okay. How did you get that? Oh, okay, I see what you're saying.
Large gap, not just gaps.
That,
Here comes Will.
That'll put everybody over to the side.
there he is. Okay, thank you, Mr. Hughes. All right, looks like now we do have everybody back, and so.
Thank you very much.
Mr. Klinger can complete.
Can we repeat the
Ms.
question?
Cunningham, would you mind re-asking the question. And just so we make the record, we're back on the record at 11:23 a.m. in case number 2020-R-379, Bud Henson et al. Mr. Klinger has finished his presentation, and Ms. Cunningham had just asked him a question when we took a break. So Ms. Cunningham, if you'd be kind enough to go ahead and ask the question one more time.
Thank you, Mr. Chair. My question really is about their argument that an individual is not required to identify themselves when they are required by the statute to make a filing of a statement itemizing independent expenditures. Specifically, I think what Mr. Klinger is arguing is that under 3517.105 C2B, which is page 6 of his argument, if anybody has it before them, he's talking about, and he argues throughout that that an individual does not have to disclose who they are when they file an independent expenditure report, and they can file it anonymously. Now, I understand the constitutional argument, which is not part of our jurisdiction, and we wouldn't be discussing that. So I'd argue constitutionally you don't have to do that, but I'm struggling with his statutory argument that the statute can require an individual to file and can require an individual to report, but that individual somehow doesn't have to disclose who they are. So go ahead.
Yes, and thank you. And Commissioner Cunningham is right that that's the statute that I'm relying upon here with this argument. I can see it's a very technical argument. Specifically, the argument is that the name field, the name requirement, the name and address of the person is not actually specified in the statute. So it is not a statutory requirement. It is a requirement added by the Secretary of State's office when they made this form. So the issue, and I think it could be one of first impression, is does the commission have jurisdiction to find a violation of a Secretary of State made regulation as opposed to something that's in the statute? So that's the basis of the argument. Again, I just also want to reiterate that the commission really doesn't need to base its decision on this argument. The primary argument to find no violation is that Mr. Henson timely amended his independent expenditure reports consistent with that grace period and is allowed. Yeah.
Can I respond to that, please?
Go ahead, sir.
I would like to bring to everyone's attention Revised Code Section 351710A, which is what I think everyone would consider the primary campaign finance filing obligation in the state of Ohio. And if I can read that, it says, except as otherwise provided in this division, every campaign committee, political action committee, legislative campaign fund, political party, or political contributing entity that made or received a contribution or made an expenditure in connection with the nomination or election of any candidate or in connection with any ballot issue or question at any election to be held in this state shall file on a form prescribed under this section by electronic means a full, true, and itemized statement made under penalty of election falsification, setting forth in detail the contributions and expenditures not later than 4 p.m. on the following dates. Now list the dates. My reason for reading that is, if the commission were to accept Mr. Klinger's argument and act on that particular aspect of his case, you're essentially saying that no campaign finance filing in the state of Ohio obligates the inclusion of a name of a campaign committee, PAC, legislative campaign fund candidate, etc. And so I would strongly encourage the commission not to act on that particular aspect of their case, because you'd be doing a heck of a lot more than just saying there's no violation in this particular case. And actually, for that matter, I also looked at 10D, which is the state, which is the section that obligates somebody to file a designation of treasurer form that creates a campaign committee. And it too says that you've got to file that form, and it's done by the Secretary of State. But it too does not specifically identify every last element of the form that the Secretary of State shall include, Because it doesn't say you have to have a name. It just says you've got a form on a form that shall be filed. So I appreciate your argument, Mr. Klinger, but you'd be bringing into a question a whole lot of campaign finance filings if you want to make that argument and have it win.
Mr. Klinger, you want to respond to that?
Sure. I mean, I guess primarily you don't need to decide this case on this argument. The main argument really is that, again, that Mr. Henshin timely amended his report consistent with the Ohio Revised Code, and that therefore he's complied with the law in that respect, and that really the Board of Elections didn't have the ability to refer this to the Elections Commission because Mr. Henshin timely amended his report.
Mr. Richter, what's your response to that?
Well, the other thing I would point out, and I appreciate what Mr. Klinger says as 351711, I think it was B3. 351711C talks about in the event of a failure to file or a late filing of a statement required to be filed under the revised code sections dealing with campaign finance, or if a filed statement, and then it goes on to say, or any addendum, et cetera, is incomplete or inaccurate or appears to disclose a failure to comply with or a violation of law, the official whose duty it is to examine the statement shall promptly file with a complaint with the Elections Commission. I appreciate the obligation that may be outlined in B3, but C1 essentially says if it identifies a statement that is incomplete, that it has the ability and is obligated to file a complaint with this commission promptly. So, I think that I would think that it would be hard pressed for us to place a restriction on boards of elections, Secretary of State's office, et cetera, under this set of circumstances to always obligate the request for an addendum under every circumstance. And so I would look at C1 as well, that indicates that the responsible party shall promptly file a complaint with the Elections Commission.
Thank you.
May I respond to that?
Of course.
Thank you. Yes, C1 is important, but it's modified by B3A. B3A sets out this requirement saying that the Board of Elections is required to accept every report filed with it on a conditional basis. At that point, it is the board's responsibility to review the report. If they see any information is missing or if it's incomplete, they then have to contact the filer. In this case, we gave the Board of Elections and the legal counsel's contact information. At that point, the Board of Elections is required to contact them to say, you need to file the corrected report with this additional information, and you've got 21 days to do so. The statute says only upon the failure to file that corrected information can the Board of Elections file a referral. So if you go to C1, which, this all has to be read in pari materia, it all has to be read together as a harmonized requirement. C1 talks about upon the failure to file that corrected form, that the Board of Elections shall promptly file a complaint with the Elections Commission. We didn't get to that point here because the Board of Elections never notified Mr. Henshin of the incomplete information. They just skipped that and went straight to the Elections Commission. Here, Mr. Henshin has complied with this grace period, and he has filed an amended report before he was even asked to by the Board of Elections. So I think you have to read these. You do have to read these two sections together to harmonize them. Otherwise, allowing a Board of Elections to file a referral without this amending procedure would be reading out the B3A language, and basically at that point the Board of Elections or the Secretary of State would really be under the obligation to promptly and immediately file anything with the Elections Commission rather than issuing audit letters and trying to resolve it. So for those reasons, I think you got to read these statutes together, and B3A creates this grace period that Mr. Henshin complied with.
I'm going to respond there just to say, you know, I appreciate his arguments. You know, they are fine arguments, but under that provision, then.
Bill, you hold on just a second. Natasha was holding in the lobby. I just want to make sure she's here to hear that.
Okay.
Yeah, I am.
He's back.
Okay.
You know, well then why does C1 go on to state that if a filed statement is required to be filed, is incomplete or inaccurate, you know, they have the ability to file. I mean, then you're you know, it's certainly possible that the General Assembly could have just said, you know, any provision or anything that's filed with the commission, because it separates statement from addendum, amendment, or other correction as well. And it, you know, it says all of those things individually. And so, again, I appreciate what Mr. Klinger says, and I believe that most boards go out of their way to make sure that they get addendums sent out there. And I appreciate what the statutory provision is, but C1 does say if a statement is wrong, that should be filed promptly. So that's, you know.
All right.
The arguments made have not changed your recommendation, Mr. Richter?
No.
That's what I assumed.
And your recommendation, again, just for the record?
My recommendation is to find a violation, but for good cause, not impose a fine. I'd be glad to address that further if the commission would like me to do so.
Yes, why don't you go ahead and do
that? Based on what the statutes obligate inclusion, you know, the information was not there. Again, I respect Mr. Klinger's arguments greatly. You know, but that's part of the reason why I'm recommending the commission find good cause. Mr. Henson was not necessarily given good information initially as it related to whether he needed a file or not. He operated under that direction from the Board of Elections. Eventually, though, he did file. I appreciate, you know, his desire to remain anonymous, but I don't think that I don't think that's what the statute at this point obligates someone to do. You're certainly welcome to make whatever constitutional arguments, and I respect those as well. But at this point, the statute is there to say if you make an independent expenditure, you identify yourself, you identify how much you expended. In this case, on behalf of a ballot issue, and you list all that information. It was not listed. That was what was referred to us, and so it was incomplete at the time. I think that's a violation. But I think that there's good cause not to impose a fine or refer the matter.
Thank you. Further questions or comments by the commission? If not, I'll entertain a motion.
Commissioner Norman, I move that we find a violation, but for good cause, not impose a fine or refer for further prosecution.
All right, we have a motion. Do we have a second? I'll second that. So we have a motion to follow the executive director's recommendation, which would be to find a violation, but for good cause, not impose a fine or refer the matter for prosecution. Further discussion?
I have a question. When after the after the addendum was filed, was it at that point, was it accurate? Because he identified himself and the expenditures?
I believe that to be the case, yes.
All right. So the only issue for us is, well, it's not the only issue, but one issue for us is whether or not when you look at C1 under that statute, the candidate, it's a violation even if an addendum is filed within the time period, it's a violation to have filed it incorrectly in the first instance. Is that what we're talking about here?
That's certainly a reasonable assessment of this case, yes.
Okay, so what it would be an alternative reasonable assessment?
If you wanted to assert that there was some sort of an obligation on the board to notify whomever and give them the 21-day period, and that was not complied with, for want of a better phrase, then you know, you could certainly make a different assessment than I did, but I believe that the original filing was not complete, and that is sufficient basis for a complaint to be filed with this commission for us to go forward.
Okay, and is it your view that the statute requires a notice, that they do accept it as a provisional and they provide notice that it's incomplete?
I don't. I believe that the board certainly has an opportunity to do that. But if they see that there is something missing in a report, I think they have an ability to go ahead and file a complaint immediately if that's their choice.
Okay.
So yes, I mean, that's the approach that I've always taken and the understanding I've always had.
Okay. And in your approach and understanding, is it your belief that even if they choose to file a report, they still have the obligation to provide them with notice and an opportunity to amend?
I don't believe so, no.
Okay.
Further discussion by the commission. All right, we have a motion that's been duly seconded that would find a violation, but for good cause, not impose a fine or refer the matter for prosecution. All in favor of the motion signify by saying aye or raising your right hand. Aye.
Aye.
Opposed, same sign.
Nay.
Okay, Ms. Cunningham's nay noted by a vote of 5-1. The motion passes. Thank you very much. Appreciate it very much.
Thank you.
Thank you,
Thanks, Derek.
All right, let's go back to case number 2021G-001, Purdy versus Simeon et al. I believe that we have Ms. Purdy present now, the complainant. We also have counsel for the respondent, Mr. Simeon, present. That's attorney Julie Mack. Is there anybody else present, Mr. Richter?
Not that has been specifically identified. No, because I don't see Mr. Simeon listed out there.
Yeah.
Mr. Richter, he is here with me.
All right, thank you, Attorney Mack.
Okay, thank you, Ms. Mack.
All right, very good. All right, go ahead, Phil.
Well, Ms. Simeon, if you would be sworn to make a further statement, do you swear to tell the truth, the whole truth, and nothing but the truth? So help you God. Or Ms. Purdy, I'm sorry, Ms. Purdy. Do you swear to tell the truth, the whole truth, and nothing but the truth? Thank you.
I affirm.
Okay, thank you. I have outlined the case. Again, your assertion is that the
respondent,
Mr. Simeon did not accurately file campaign finance reports and was held certain campaign finance information from you. We'll eventually hear from Ms. Mack on behalf of the respondent, but please address the commission with whatever else you believe may be helpful to them to assess this case.
Go ahead, Ms. Purdy.
Hi, good morning, and thank you. I thank you for working with me with the technical problems that I'm having. It's an honor to be here. Again, I'm Kathleen Purdy. I am the complainant. I sent down the affidavit, and just to rehash our issues is that as the elected president of the Alliance Area Democratic Club, we still, as of today, have no access to our PAC checkbook or PAC funds, despite the fact that our treasurer was able to obtain an online account password, and it showed that monies were removed from the PAC account through a ATM on January the 8th. $100 was removed from a PAC account that the former president has no idea. The former president or treasurer / of the PAC has no idea about this account, but $100 was removed on January 8th via ATM, and or I'm sorry, it was deposited on January the 8th, and $500 with check number 109 account with no knowledge of this account. And on the same date of January the 8th, $100 was deposited. $100 was removed from our Huntington Community Business checking account using check number 2155. $100 was removed from a Huntington Community Business checking account, and that account is under the signers of a Gwendolyn Dunnigan who moved with her husband to Georgia some years ago after resigning. So as of today, as we're speaking, with no information and nobody knew anything about accounts as recently as January, and I took over January 1st. We also have problems with our PAC, which in September, signs. It was signed. It was a check. It was signed by a non-signer, registered through Huntington Bank for $250 up on in-paying filings as well as a PAC account. And in October, we approved $500 from our PAC to go for the candidate running for the 50th House seat, and that is not revealed on any. The general account is active. However, in 2016, the EIN numbers don't match that general account, but they do match a PAC account of which we've been told that everything's been turned over, and that's not the case. And it's very misleading for us to have thought that our treasurer had resigned, and therefore active statements that the banker told us were still being sent to her Alliance address. As the president, it's my responsibility to make sure that all the members' monies are being utilized with approval from. So we have been financing out of our pocket because of this resistance of the former president to continue to say, have no idea about this PAC account, have no idea about a PAC account, and yet still monies have been removed. And we still don't know, because of the campaign filing from January, whether we have $400 or $6 in this PAC account. Henceforth, my trying to go up the ladder and to try much resistance as of today, we still don't have these materials that we need. We can't open up in a new account because there's no EIN number, which I understand now was not required when the general account for our Alliance Area Democratic Club was open. It was not required to have an EIN number. Today, that is different. You have to have an EIN number and you have to have it registered through the state. So it just created a lot of unnecessary time, waste, and frustration. We're all volunteers. We are civic, and we just wanted a smooth transition, and someone has decided that's not going to happen. Henceforth, why we're here today on the 22nd of April. I did send a letter, and I believe you have it in your possession, as of why immediate suspension from Brian Simeon from the Alliance Area Democratic Club. We're still without banner for funds from the Alliance Area Democratic Club, as well as our car magnets. Those were to be turned over by March 31st and to pay dues to remain in good standing. And I know it was tough for him because we've run like Mayberry for a number of years. We have been like Mayberry. So, but that's no excuse. The reason with turning over materials that we need.
Anything else, Ms. Purdy?
Hello?
Ms. Purdy, anything else?
Yes.
I'm sorry, you froze for a moment in time there.
I just don't want this. Complete that moment.
With all due respect, I can't hear most of what she's saying.
I can't either.
Okay,
Thank you.
Yeah, Ms. Purdy, you're breaking up, and generally speaking, most of what you have said, I think, has come through, but there are times when it has been hard to hear what it is that you are trying to say, so I'm not asking you to repeat anything at this point. Presumably you can hear me, the other commission members. Is there anything else you wanted to add? I think the commission has an understanding of your complaint.
Yeah. Yes.
Go ahead.
One
then.
more. We need the PAC account checkbooks. Was I clear? Did that come through?
Yes.
It didn't. It didn't for me.
It didn't
said
for
we
me
need the PAC
either.
account, and that's all I heard.
She said she wants the PAC account checkbooks. At least that's what I heard. Was there more than that?
No. No, that's correct.
Okay.
Okay.
Go. Is there anything else, Ms. Purdy? And please take your time. We'll work through all these technology issues if necessary. I want to make sure you have an opportunity to share with the commission all your thoughts.
And break it up as well. So I will go so fast. I'm one of 7 to speaking quickly, and my years in the classroom. I would like to say that we our Daddy Club banner that we use for our car that we use for our parades that will probably be happening here in a couple months. And we need that at $600
I'm hearing every like 5th word.
Without in January.
Yeah, the commission hardly heard any of that last statement, Ms. Purdy. You kept breaking up, and so I'm not sure what the problem is. I wish I could offer you more, but whatever you, the majority of what you just said did not clearly come through.
And I believe it had something to do with the banner she needs back, so they don't have to pay for it again, but I don't think that's what's before the commission today.
No, yes, no. Thank you.
All right. All right, let's do this. Ms. Purdy, what I'm going to do is going to go to the respondent, to Attorney Mack, and allow her to say some things in response to that. And then once she's finished, we'll come back if there's anything else that you want to say, and then the commission may have some questions too. So, Ms. Mack. Are you ready, ma'am?
Got it. Okay.
Okay, just making sure I was unmuted.
No, you are.
Yeah, you are now. Go ahead.
Thank you, Mr. Chairman, members of the commission. As I believe you just heard from Ms. Purdy, her complaints about my client, Mr. Simeone, are largely personal and unrelated to the function of this body. However, to go back to her original complaint and the allegations made therein, this all basically goes back to the club voting to provide $500 to Mr. Simeone's 50th House District race campaign. There was a check that was written at the end of October 2020. That check was not deposited until January. After the activity period for any of the reports that Mrs. Purdy has reviewed and claims things are missing from. Once the check was deposited, there was a check written from the club to the PAC. Once the PAC had that money in January, there was a check written from the PAC to Mr. Simeone, his campaign committee, Friends of Brian Simeone. Once that check was received by Friends of Brian Simeone, it was deposited into that appropriate bank account. So there's 3 financial transactions that happened there effectively. Nothing funny about that. There was a delay. Mr. Simeone owns a small business that was fortunate enough to be very busy at the end of 2020. And so his small business took priority over his campaign for the 50th House District. There's just because he had this check it was not deposited until January. And so it was not activity that he could have disclosed. It was not reflected in the bank accounts. It seems Ms. Purdy has a number of issues related to the various financial institutions and the different responsibilities of the club versus the PAC. However, I don't believe that this body has jurisdiction to wade into those, particularly as it relates to property. We provided in our response an affidavit from Mr. Sam Ferruccio, who is the chairman of our Starr County Board of Elections and the chairman of the Starr County Democratic Party. He has been engaged with both Ms. Purdy and Mr. Simeone, has not found that there's anything going wrong here except a clash of personalities. And I believe that my written response speaks for itself. Do all the commission members have that, Mr. Chairman?
Yes.
Okay. I believe that's all I have. I'd be happy to answer specific questions. My client is also here, although he would prefer that I answer on his behalf. I'm well aware of everything that has gone on, but we're happy to answer any questions that the commission has.
Thank you very much, Attorney Mack. Any questions for Ms. Mack?
Yeah, I guess I have one, Ms. Mack. You mentioned a $500 check. In the material that we were provided previously, I saw a reference to that $500 check. But when I look at the allegation, it says the complainant asserts that the respondent has not filed complete and accurate campaign finance reports and withheld campaign account information for the local area club/PAC. Well, could you address that? That seems to be the allegation.
Certainly. So the club voted to make a contribution to Mr. Simeone's State House campaign. When the club votes to contribute money, the money comes from the PAC. However, at the time that the Alliance Area Democratic Club voted to contribute that $500, they didn't have $500 in the PAC. And so a check for $100 was written from the club to the PAC so that the PAC would have $500 to be able to contribute. Once that check was written, it was not immediately deposited. So the PAC did not receive that $100 until January. Once the PAC had received that $100, the $500 check was written to Mr. Simeone's campaign. Once Mr. Simeone's campaign had that $500, it was deposited into his bank account. But those transactions did not happen until January, despite the fact that the club voted in October and there was a check written in October. Nothing was deposited until January of 2021.
So you're saying that the reference to has not filed complete and accurate campaign finance reports all centers around that $500 transaction?
Yes, I believe Ms. Purdy is mistaken in believing that when the club voted, those things happened instantaneously. That's not the case. If Ms. Purdy had simply asked Mr. Simeone that, he certainly could have clarified, but rather than doing so, she brought this to the commission.
Okay, thank you.
Other questions, Ms. Cunningham?
Sorry, I have a couple follow-ups. Maybe I'm just not following the facts accurately enough, and I apologize. So we're talking about the PAC. Who's the treasurer of the PAC?
The treasurer of the PAC is a woman named Mona Henderson. My client, Mr. Simeone, is a deputy treasurer of the PAC.
And so is there a single PAC account, well, only one account for the PAC?
Yes.
And where is that account?
It is with Huntington Bank, correct? Yes, Huntington.
Okay, and then I think what you are saying is there is a separate and distinct account for the club.
Correct.
And who is if you know, who's the treasurer of the club's account?
My client has never had access to the club's bank account. He was the president for a period of time, but he never had anything to do with the banking transactions or activity of the club.
And do you know who the treasurer of the club account is?
Do you know who has access to that account?
When me and Dave went to the bank last year, they said Carolyn, which was a previous signer, was the only signer that was still on, is what we were told.
No one that's a party to this, ma'am.
Okay. So, Mr. Chair, I guess I'll ask the executive director, if we're in a preliminary hearing and getting information from somebody who hasn't been sworn and not testifying as a witness, do we need to have him sworn?
I would say yes. If
I don't
if
think
he's
that's
going to produce information, yes.
right, because I don't think otherwise it's technically information before the board.
Mr. Richter, go ahead and swear the witness if you would, please.
Mr. Simeon, do you swear to tell the truth, the whole truth, nothing but the truth, so help you God?
I do.
Please, go ahead then.
Okay. So my question, Mr. Simeon, is I think through your counsel, you provided information of who is the treasurer of the PAC, if you know.
Okay, Mona Henderson is currently the treasurer of the PAC, and I'm the deputy treasurer. And I do the filings for the PAC.
Okay. So the filings that are done at the local board of elections for the PAC are done by you?
Yes, ma'am.
Okay. In your capacity as the deputy treasurer?
Yes, ma'am. Because Mona doesn't have that she doesn't understand fully how to file her. So she has no computer access or anything, so I file everything.
Understood. Is she if you know, is she the designated treasurer on the form that's on file at the board of elections?
Yes.
Can I stop for just a second? We have Ms. Purdy waiting in the lobby.
And a lot of feedback.
We had Ms. Purdy waiting in the lobby. I want to make sure she's here to hear all this. Chris, is she back in?
She appears to be back.
She appears to be back in, yes.
Okay.
Right, thank you.
Okay, so.
Can you hear me?
Yeah.
Yes, yeah, we can, ma'am.
Okay, because he kicked me out for some reason.
Yeah.
Okay. Well, we're talking to Mr. Simeon right at the moment.
Okay, so there's an allegation that accurate reports have not been filed by the PAC. So is there any truth to that allegation, or can you give us a response to that? Have the reports been timely filed, and is it just a matter of the timing of the payments, or what's happening?
Yes, I think Julie answered that. It's just the timing of the payments. As of today, I have another, because technically, and the reason why I have not turned over the bank account information for the PAC is I'm still the deputy chair. I'm still in charge at this point. So today, I'm actually planning on filing this afternoon the report for the pre-primary that will list the $100 from the general fund to the PAC, and then the $500 donation from the PAC to my campaign fund, which happened this year. So everything was filed last year that was supposed to be filed. It's a whole misunderstanding.
Okay. When you say everything was filed last year, is what you're saying as it relates to the PAC, all of the PAC reports were filed timely and appropriately last year, in your opinion?
Yes, mine, the PAC and my personal account, I filed both in January. I filed two yearly ones for the whole year. Everything has been filed properly.
Okay. And when you say for my account, what account are you talking about?
Friends of Brian Simeon committee, because I believe there's both of those are in question here from what I understand.
Okay.
So this morning, actually, I filed the one online with the state for my state one, the Friends of Brian Simeon, which now reflects that $500.
Okay. And Mr. Richter, if you could weigh in on the timing and due dates of those reports and whether they have timely filed, and certainly I welcome any additional questions to the witness in that regard.
Well, the only thing I have is everything that you have, and otherwise, it appears that everything was otherwise timely. I have not actually looked at the reports to know. I'm presuming that whatever was filed with the Stark County Board, I don't know what the Stark County Board's opinion is. Some of this involves, as it could be phrased, I guess, Ms. Purdy, quote, taking over and moving forward. What's the process, or is there a process in place in order to either have her as treasurer, or is Mr. Simeon going to give up the treasurer position? Is Ms. Henderson going to retain, that, I guess, just out of curiosity, what's going on with that, because I believe some of Ms. Purdy's concern is that she's taking over and not being provided with information, and there isn't apparently some sort of a succession in order here. What's the status of all of that? If you are aware, Ms. Mack, or to Mr. Simeon.
Well, and that's where this gets tricky, because there's a significant difference between the club and the PAC. Ms. Purdy is the incoming president of the club. That does not necessarily automatically put her in charge of the PAC. And because Mr. Simeon is still the deputy treasurer of the PAC, he has not resigned or otherwise tried to withdraw himself from those responsibilities until he's sure that everything has been properly filed, all the information that he has can be provided to whomever is his successor. But right now, he is still the deputy treasurer of the PAC. Ms. Purdy has not made a clear request to him that he either resign or be replaced by somebody else. And as the commission members may be aware, without somebody assuming that role, if Ms. Henderson, and I'm uncertain of her role and level of responsibility here, he doesn't want to abandon the PAC and have something go wrong and something not filed. So until somebody else steps in, he's kind of on the hook, but he would like to walk away from all of this.
Okay.
That's all I have for right now. I may have something else here, but.
Okay. Any other questions or comments by the commission?
I don't have any of Mr. Simeon, but I would like to hear Ms. Purdy's response. I'm from her complaint and from what the testimony has been, I'm having a little bit of hard time siloing who's where, and
sure.
whether the PAC really, had a vote and changed over its leadership and, elected a new treasurer, or whether we were talking about the club that did that and how those connect.
Well, Ms. Cunningham, why don't we go back to Ms. Purdy to see what her response is. If you have any specific questions, why don't you go ahead and ask those questions of her now. Ms. Purdy, can you hear me?
Yes.
Okay.
Yes, I can.
All right, just so you understand, we've now, at least for purpose of our preliminary hearing, have heard from counsel and from Mr. Simeon, and the board's had a chance to ask some questions. So we're going to kind of come back to you and ask what response, if any, you have to what Ms. Mack or Mr. Simeon said, and then the board may have some questions of you as well. So the floor is yours. Go ahead, ma'am.
And thank you. And because of the poor connection, there's a lot that what Attorney Julie was saying I did miss. However, just to pretty much wrap it up as to where our concerns are and the rebuttals, as far as looking at a PAC, yes, on record with the Board of Elections, the deputy treasurer and the treasurer, those are different documents. According to our Constitution and bylaws, the president has the opportunity to replace the deputy treasurer or the treasurer, which I did in the February minutes. I believe Brian was on that Zoom meeting. All of our meetings are virtually. However, we cannot place someone else in that position. And I agree with Attorney Mack. Brian doesn't want to abandon a account that he's on. However, no one will take that on, not knowing whether or not there's $400 in the account or if there's $600 in the account. And if the filings are complete, and because he says he has no idea about the PAC accounts, which today's testimony, he knows something about the PAC accounts, but that's only because our treasurer was able to, with the former holder of the passcodes, and get that information. Had it not been for right now, I'm holding in my hand actual Huntington Bank's online information that money was withdrawn in January, clearly after he left office, then we would not be having this conversation. So yes, the Board of Elections did tell me that filing is different. The filing is designation of treasurer. That's different than what we have on our Huntington PAC account. Brian and Mona Henderson are both still actively signers on a PAC account that we know nothing about and have not in our possession. It is, when we talk about clash of personalities, those are like buzzwords. For me, it's business. And this is business. This is not something that I'm taking pleasure out of, because I've had a relationship with Brian for well over 10 years. And so it's not a personality clash. It's just merely just saying, just reasonably having a smooth transition. We cannot move forward if we don't have this information, if we don't even have checking accounts in our hands. I was at a bank and they said, do you even have an account here? I said, I have no idea where our accounts are, because nothing was left. So clearly, if you want to do housekeeping, it should have happened in October when we did nominations for the offices. And then those materials should have been turned in at our last meeting in December. Nothing was turned over, and we're still here. We're almost into May, and we still do not have the PAC information.
All right.
Mr.
Ms.
Chair.
Cunningham,
Yeah, my only question, I'm sorry, to the witnesses, Ms. Purdy, when you're talking about all of your testimony that you just made, are you talking only about the PAC and not about the club?
I'm talking about both of them. Because we have two accounts. We have our general fund. Go ahead. I'm sorry, ma'am.
I'm just trying to understand the difference between these accounts. So your club account is an account that the club has, and you have no filings with no filing obligations with the Board of Elections or Secretary of State on that. Is that right?
That's correct.
Okay. And then separate and distinct from that, there's a PAC account, and the filings that are due in the PAC account, there are filings due with the PAC account, and the filings with the PAC account are due with the Board of Elections and Secretary of State, correct?
That's correct.
Okay. And when you're describing the difficulties that you're having relating to obtaining information or whatever it is relating to your accounts, are you talking about only the PAC account, or you're talking about both the PAC account and the club account?
I'm speaking about both our general account as well as our PAC account.
Okay.
The PAC account with the filings. And I had gotten a notification from the Board of Elections that we were due a filing in December if we had contributed to any candidates or political activities. And I said we did, because in September, we reimbursed for Biden signs. And we also in October provided $500 for Brian's campaign for House District 50. So she said, well, you need to get in touch with them, let them know they have to file. The filing is due. And so I did reach out to him, and he pretty much told me that no filing is due, but I guess there would have been if none of the checks were cashed or presented.
Okay.
Thank you, Ms.
So we
Cunningham.
don't have jurisdiction over the club account, do we?
Pardon me?
Potentially, but the answer is no here.
That was for Mr. Richter, ma'am.
And so really what we need to do is focus our focus needs to be on the PAC activity, nothing to do with the club activity.
Correct.
Right.
Okay.
Well, if I may, the general account is written, who's writing checks on her general account, if she lives in Georgia and she resigned 5 years ago from being our treasurer, who's writing those checks and where are those checks?
Ms. Purdy, is that referring to the club account or the PAC account? Because we don't have jurisdiction over the club account.
Okay. That was the
PAC account,
complaint for the misleading.
Is that the PAC account or the club account?
What I just said was the general account, but right now the biggest concern is the PAC account. I'm sorry.
Well, I want to make sure I understand, because you use general account, and I don't know if you're referring to your club account or your PAC account, and I want to make sure we're clear on that.
Yes, and the three violations that I was alleging, one was we just had discovered that our general account, the
Ma'am, can I
signers,
stop you?
Ma'am.
yes,
I want to understand, when you say general account, are you referring to your club? Or are you referring to the PAC? Because we need to know the difference.
when I say PAC, I'm referring to the PAC account.
So when you
The
say general
PAC
account,
account
you're
and the
referring to
PAC account filings.
when you say general
Because
account, are
we
you
don't have a
referring to the
lot.
club?
Just a moment,
When I
Ms. Purdy,
say-
Ms. Purdy, just a moment. Mr. Norman, go ahead and ask your question again, please.
Ma'am, if you refer to the general account, are you referring to the club account?
Yes,
All right, and I think what's been said, ma'am, is we don't have jurisdiction over your club account. The jurisdiction the Election Commission has is over the PAC account.
yes. That was just part of what I was saying, but I understand that. Let's go then. We're strictly now, I'm talking from this point on, our political action committee, our PAC account
Okay, go
and
ahead.
those
ma'am.
filings.
Go ahead, ma'am.
Is that to Kathleen, to me?
No, Mr. Richter, you had made a recommendation that we set this matter for hearing. And I guess the question that I have for you is, have you heard anything this morning that would cause you to change your recommendation in that regard?
No, because it's, I mean, I find the situation, for want of a better term, confusing, I guess, as much as anything. And after reading the complaint, there's various things about, talking to the chairman of the party who said, well, he was understanding that certain things were going to be turned over, and they haven't been turned over. And I don't know whether that's a resolution of this or not, but it is what I would feel at this point is the best approach to try and take to help resolve this situation.
All right. Any other thoughts by the board on that?
Phil, I have a question to you. Has the Stark County Board of Elections been involved in this at all?
I have not had any conversations with them, no. So I don't know what has gone on between, let's say, Mr. Simeon, Ms. Purdy, the board, et cetera, aside from what was laid out in Ms. Purdy's, in the original referral or the complaint, and the comments that, Mr. Simeon's comments in his response, and the response that was also included from the chair of the party who works on the board, but I don't know what, whether he had actually discussed anything with the staff of the Board of Elections as it relates to this either. I don't know the answer to that.
I think we have enough questions here that we probably just need to go ahead and set this matter down for hearing and use the hearing as an opportunity, hopefully to have more information and to be able to sort through and make a decision.
May I address the board again very briefly?
Yes, ma'am.
If I could draw your attention to the exhibits that were attached to the response that I filed on behalf of my client, you can see when the checks were actually deposited and that none of that activity took place until January. Therefore, the reporting requirements that Ms. Purdy seems to be focused on do not apply because there was no activity until January. The 2020 annual report is to disclose activity through December 31st. None of this activity happened prior to January 8th, 2021. And so the violations that Ms. Purdy alleges can be clarified simply by reviewing when those checks were deposited. And since those checks were not deposited until January, there was no failure to file or failure to disclose activity.
Thank you, ma'am. Questions, comments?
Mr. Richter, would you agree with that?
That would appear to be the case, yes.
So is there a need for another hearing? Set it down for hearing?
Well, do we have, we don't have a copy of the report, do we? To even know what activity was reported?
I don't believe so, no.
Yeah, I don't know how you resolve
don't-
it without seeing the report.
I would agree. All right. Anything else from the board or the commission, rather, excuse me? Do we have a motion to go ahead and set this down for hearing?
Cunningham, so moved.
We have a motion from Ms. Cunningham. Do we have a second to that motion to set it for hearing?
Second, Kaufman.
A second by Commissioner Kaufman. All in favor of the motion to set this for hearing, signify by saying aye. Or raising your right hand. Aye.
Aye.
Aye. Opposed, same sign.
No.
Motion carries by a vote of 5-1.
No, by a vote of 4-1.
4-1.
Mr. Beatty left the meeting
Okay.
because he had a previous commitment that commenced at like 12:15, I think it was.
All right,
And so it was 4-1 with Mr. Bromer voting no.
got it. Very good.
Can I make a statement? Ms. Purdy, when you come back next time, it might be beneficial to us if you come in, instead of doing your computer audio, use phone audio, because you were glitchy is probably not the correct technical term, but we had trouble hearing you. And make sure that you focus not on the club activities, but we're only here talking about the PAC activities and the accounts dealing solely with the PAC, but not the club.
And if I can also make a comment, I would suggest that if the parties are able to resolve this, we welcome our executive director is always willing to work with the parties to get resolution. So if in fact you come to a resolution, the commission would consider that rather than, a full hearing on the matter. So I encourage you, if you can, to try to resolve whatever issues there are, if you can do it.
And Ms. Mack, Mr. Richter would meet with both you and Ms. Purdy. He could get on conference calls to kind of talk through these issues, if that would be helpful.
Absolutely. Thank you.
Okay. Thank you, Ms. Purdy, and thank you very much, Counselor. We very much appreciate it. We'll look forward to hopefully seeing you here in the next month, okay, for a hearing. And it has been indicated, if it can get resolved between now and then, that would be fantastic, but that's your call. All right.
Thank you.
I appreciate your time, and I'm sorry I extended your day by 30 minutes with the technical problem. So
no apology necessary, Ms. Purdy. That's fine. Thank you very
so
much.
thank you again.
Thank you.
Okay.
Very good. All right, so that concludes that matter. The final matter on the agenda is a hearing that we have scheduled. It's case number 2020 S-002. Anthony Nino Vitale. You'll recall that on December the 17th, 2020, the commission first addressed this matter at a preliminary review and heard arguments from Mr. Vitale's counsel at that time, Donald Bry. At the conclusion of the presentation of evidence at that time, the commission decided to find a violation of allegation number 1 in the complaint and to find that there was good cause present not to impose a fine or refer the violation for further prosecution. So the commission has before it today counts 2 through 6, and that's what's been set for hearing. I guess I was going to say this morning, but that's now this afternoon. Mr. Vitale, good morning, good afternoon. I know you've been on for a while. Welcome. As I understand, Mr. Richter, the Secretary of State, is not going to be present today. Is that correct?
I believe that to be the case, yes. I mean, I've had general conversations with the staff that they, submit their complaint or referral. They believe that that in and of itself is sufficient to establish, what they believe to be the proper standard. I mean, I will put out, just while we're here, is there anyone present who will be appearing on behalf of the Secretary of State in this matter? If so, please speak up. Not hearing anything. Okay. I think that, has proven to be the case. And so the commission has all the documentary materials from the original complaint, the original response that was submitted by Mr. Vitale back in January, back in December. In addition, just this morning, Mr. Vitale circulated some materials to me which I then recirculated to everybody. So you would have received an email from me this morning that has, I believe, the outline that Mr. Vitale will be going through today as it relates to the allegations. And so, Mr. Vitale, considering you are appearing pro se on your behalf, will you be sworn and swear or affirm that the testimony you are about to give to the commission is the truth, the whole truth, and nothing but the truth?
I do.
Thank you very much. I was going to say, go ahead, Mr. Chairman, if you would like him to proceed.
Yeah, I would, but before that, Mr. Vitale, I just want to make the record on this. At the previous hearing in December, you were represented by Donald Bry, and I believe in the communication you had with the commission this morning via email, you indicated that you were no longer represented by Mr. Bry. Is that correct?
Can you hear me okay, first of all? I know
yes, we can.
Okay. Yeah, so I just to be technically correct on that, I opened by saying we felt it best because this commission in the last hearing wanted detail, and Mr. Bry and I felt the best person to give that detail and answer any questions the commission has is the person who actually did this, manages the campaign, and that would be me. So it's not a matter of he's no longer working with me. It's just a matter of I'm representing myself for this particular hearing so that I can directly speak with all of you and go through any questions you may have.
I appreciate that very much. I just simply wanted to make sure the record was clear as to why Mr. Bry was not here.
Yes.
All right. With that, the floor is yours, Representative Vitale. Go ahead.
Okay, I'm just going to go through my document.
Just one second.
I'm sorry. What, Scott?
This is Commissioner Norman. I received a copy of that this morning and his response. And my question was, I didn't see that it was notarized, but can we have him verify on the record today that that was true and accurate and that is his testimony? So we don't have to repeat the entire document that we all read this morning, which I believe is his information. Can we do that?
Did you hear that, Mr. Vitale?
I did, and I did sign the document on page 8, and I asked several days ago if notarization was needed, and so I wasn't sure about that, but I did not get a response. But yes, it is my fair and accurate statement, and you all should have a 9-page PDF that hopefully was emailed to you by the director.
This is Commissioner Norman. I received that this morning, and what I didn't want you to have to do was go through and recite everything in your 9 pages. I reviewed it. It wasn't notarized, but I just wanted to make sure that that was going to be your testimony so we didn't have to go verbatim line by line.
Okay, well, I do feel it's important to make a few points in there.
That's fine.
No, I appreciate that.
Certainly.
I wanted your document on your behalf to be part of your testimony and part of the record.
Thank you. I appreciate that. Okay, I'm just going to hit a few remarks in here. On the pages. I realize some people may not have had the opportunity to go through this, so I just want to make sure we cover the highlights because there are details in here. I appreciate the fact that maybe some have. I've spoken about Mr. Bry, Attorney Bry. This is no reflection on him whatsoever. I think we've talked about that. The second paragraph there, I handle my own finances related to the Ohio House, and I raise and spend very little money. I'm one of the least expenditures or fundraising people in the House and the Senate, and that's shown through the past 7 years of me being audited by the Secretary of State. In the time of this violation, which would have been pre-primary, the primary of 2020, I had no opposition on the ballot. So there was no other name on the ballot other than my own. So there's obviously not a big fundraising issue going on with me. Okay, now to move on to the complaints that were filed. You've already gone through complaint 1 in the executive commissioner had summarized. We already covered that in the last session. So I'm going to move on to complaints, the following complaints, and they are to some degree wrapped up. So I'm going to kind of group them. First of all, the Secretary of State stated that there were charges made under $100 and no paid for by the committee byline. To address this first issue, I was advised by the Secretary of State representative years ago, and frankly, several other attorneys in the House, that the paid for byline should be located in the About This page section of Facebook and in social media. So as you can see there on page 2, you should have an image. That is the paid for byline and has been that way for 7+ years that I've been in office. I would point out that that's very similar to a campaign mailing where you don't put the paid for byline on every single face of the mailing. You put it on one face, or a TV commercial where you have the plate at the bottom, usually toward the end of the commercial, but it doesn't, the paid for byline doesn't run for every single post. So it is there, it has always been there. This count alleges I failed to report the expenditure. If you look at the Secretary's own Form 31N, it states that unpaid invoices do not need to be reported. What's more, if I'm not billed by an organization for a charge, I cannot report something that has not been charged to my campaign. That to me would be fraud, as it would be filing a charge that has been unrealized. We do the same thing in the business world. I don't pay people bills until they've sent me an invoice. For the past 7 years, I've filed detailed expense reports on almost a quarterly basis with the Secretary of State, all backed up with any type of credit card charge or receipt down to the penny. And I have been audited probably no less than 13 times by the Secretary of State and passed all of those audits. Moving on to page 3. I show a charge there from Facebook that did occur during this time frame, which is one of the 3 charges that are in question. And as you can see, that charge is listed. It's a little small there. That's August 31 on the credit card statement. And I would note that the complaint to the Elections Commission was filed on August 25th. So clearly this charge and the subsequent other 2 charges came in after the report was due and even after this complaint was filed to this commission. So let's see. Yes, okay, so just to reiterate, Form 31N also states if the debt is less than 60 days outstanding, it does not need to be filed. So even if these 3 charges or any charge fell within the time frame, there's still a 60-day window to report them on the next filing or to amend a current filing, if you will. And amendments to reports, campaign finance reports, happen frequently. Okay, moving on to complaint 3. Contributions to a CCW class. This states my campaign received fees for classes that were contributions to my campaign. I have taught concealed carry classes since before I was a state rep for over 8 years. I believe the Secretary of State may be confused and think I'm receiving funds for the campaign and mixing the class funds with the campaign. The graphic below is a screen capture of the sign-up form from August 19th, back when during this time period. And this sign-up form has been the same for many, many years. It clearly states on the form, underlined in red, quote, "This is not a campaign contribution," and even the word "not" is depicted in all caps. This is on the public website that any of you or anyone can go and see, even without signing up for the class. Moving on to page 4. Most people use Venmo today, probably around 70% for the classes that I've taught. However, there are some that do use that Pyrex system. If one were to follow that link, we had been using that same company for the campaign and for the classes. I was told this was allowable as long as detailed records are kept and noting which are contributions and which are payments for the class. There's also nothing that I can find in Ohio law that states this is not illegal, which is probably why I was given advice that this was appropriate. Okay, the sign up clearly states the person is not donating to the campaign. Just so you all know, we no longer use this form because of this confusion that developed. You know, when you're told something's okay and then somebody files a violation like this, it's like, well, let's just eliminate this altogether. So that has been, we no longer use that for the classes. Okay. Further, I wanted to present some evidence to you all. This is third-party evidence. A reporter called the Secretary of State's office, and then that reporter then called my state office and left a message on my state system. So this is all a matter of public record that anyone could ask for without subpoenas. And what I'd like you to do, this is a reporter who is absolutely not fond of me and has written many negative articles about me, unfortunately. But that happens in politics. And what I'd like to do is play the audio of that voicemail to you and listen to what the reporter says about what the Secretary of State said to him about these violations. Now, they weren't yet violations because this, sorry, I'm pulling up the email on my phone so I can play the audio off the phone. This came into my state office on July 16th of 2020. And just as a reminder, the complaint that went to you all was received on August 25th. So this is about 5 weeks or so prior to the complaint being filed. Here's that message.
Hi there, this is Tyler Buchanan. I'm a news reporter with the Ohio Capital Journal, trying to reach Representative Vitale. I've been looking into this week, the representative offering the CCW training classes and then taking in payment through campaign contributions, and just thought it was kind of like an interesting campaign question. And I had reached out to the Secretary of State's office, and they've told me that, looking at the situation, that everything seems to be on the up and up. But I do intend to still write about it, just as kind of an interesting campaign situation. And just wanted to offer the representative or his campaign a chance to comment on it or provide any other context. But just wanted to let you know I will be writing about it for tomorrow, which is Friday, July 17th. So if you want to reach out to me anytime today, Thursday the 16th, my number is 419-217-3773 and 419-217.
Okay, that's the end of the voicemail. Note that he said he reached out to the Secretary of State's office and everything seemed to be on the up and up. But 5 weeks later, there's a campaign violation being filed that, and all of these center around that very issue. If you look at it may come out green if you printed it in color, but it's at the bottom of page 4. What this shows you is how we handle the CCW classes. We capture information such as the exact date and time someone signs up, their email address, their full legal name, telephone number, their full regular address, their age at the time of the class, and then some other information, including in column I there, how they pay for the class. So we keep extremely detailed records. This is a screen capture of an August class during this time frame. And you can see there were 3 people that signed up for that particular class. We keep these fairly small. Anyway, so we do keep very detailed records, and it's very easy to see who signed up for a class versus if someone is actually contributing to the campaign, which during this time frame, no one actually did contribute to my campaign. So it was fairly simple. Okay, moving on to 5. Count 3 states I failed to report contributions. But as you can see, detailed records are kept and no contributions were made. So I did not fail to report these people because they were not contributions. The past 7 years of reports show a history of detailed reporting of any of my contribution and expenditures. I've been commended in the past by the people at the Secretary of State's office for my detailed reporting and backup documentation that I provide. It was even noted to me by a person at the Secretary of State's office that they are not sure why the Secretary of State filed complaints against me when my 2020 pre-primary had not even been audited. And in fact, the audit from the Secretary of State came just a few weeks ago for that time period, and nothing in that audit has anything to do with the complaints that were received. They were fairly routine questions and about backups, or you wrote a check to this person and you missed providing the check, the canceled check, those sorts of things, which I tend to provide. Complaint 4, failure to report MailChimp fees. This is still on page 5. MailChimp is a service that allows people to sign up on an email list to receive updates. You're probably all familiar with that. MailChimp has a free option. If you're under a certain amount of subscribers or sends within a period of time, you don't have to pay for the service. My list for 7 years has been under that minimum. And as you can see below with the screen capture from April 11th, just about 10 days ago, there's Friends to Elect Nino Vitale. It shows I'm on a free plan. So again, I can't report something that is, I didn't fail to report something because it's not an expense to the campaign. Okay, moving on to page 6, count 4 states that I failed to report these expenditures. But again, it's tough to report something that's a free service. Complaint 5, commingling of funds between the CCW class and the campaign. I've tried to show you in the previous screen capture that I keep very detailed records, and it's very easy to see who donates and who doesn't. Complaint 6, personal use of campaign funds. Count 6 accuses me of converting campaign funds to personal use. This count, however, gives no detail on where or how this was done. It also does not state what it was used for, so I can only assume this is in reference to the CCW classes. As I've shown above, I keep detailed records and keep the funds separate. Never are these funds used for any campaign. Although I have heard of many people having fundraisers using firearms to raise money for their campaigns, this was most recently done by former Representative Ron Magg, and I would point to you to the headline and link that I provide there on page 6, which states, it seems like this is from the Cincinnati Enquirer. It seems like a catchy little phrase. That's how State Representative Ron Magg defends the decision to call an upcoming campaign fundraiser a machine gun social. So there's the link for that. And then on the next page 7, there's the headline and screen capture of that. Okay, so in summary, Revised Code 3517.11B3 states that when the statements such as mine are filed with the Secretary of State, the Secretary of State is mandated if they have questions, they're mandated to review that report, audit that report, and if there are questions, they are mandated by law to approach the committee in writing and say, these are the questions we have, and we need you to respond to each one of the questions that we may have. Maybe one question, maybe 10. Some of my audits have involved 10 or 15 different questions. Some of them have involved 2 or 3, and I always respond with a very detailed in-writing response. The Secretary of State did not follow the law in this case and never gave me the opportunity to respond the way I have done in 7+ years. Okay, so moving on to the last page here, page 8. Either way, I have nothing to hide. I've tried to comply with all election laws in the state of Ohio, and hope you can see with this detailed explanation I've laid out for this commission to help it come to the determination. You know, I have a full-time job outside of the state rep and outside of the CCW. I work at a factory in Urbana, Ohio. Honestly, that's my bread and butter. So the classes, any instructor will tell you, the classes are not a way to feed yourself or your family, especially one like mine with 5 boys, and boy, can they eat. So I truly just care about educating people. And as we've seen, sadly, over just the last couple of days, firearms are a very divisive issue, even when our law enforcement uses them. And I'm just simply trying to teach people safe gun handling and what's appropriate in the law. Just to close, below our records of contributions, I thought this commission would be interested in. I make sure that I donate both personally and through the campaign to the soup kitchen in my local area. And I just believe the voicemail and the information I've provided here shows that I've been keeping detailed records. The Secretary of State was pretty clear with the press that there's nothing to be filed. And over the past 7 years, nothing has changed with the way I've done things. But all of a sudden, something changed in August where I was not given the chance, as the code says I'm supposed to have, in writing to respond, yet violations were occurred. So I thank the commission and for your time, and I'm happy to answer any questions you have on any of this.
Thank you very much. Questions by the commission? Or the executive director?
I have a question about the CCW contribution, or somebody who was taking a class who actually used that Pyrex system. Did those funds ever inadvertently get deposited into your campaign committee account and then have to be adjusted or paid back out?
By law, they're allowed to be put into the same account, but records have to be kept and then they have to be transferred out. There was a prior case before this commission of this happening several years ago in Franklin County, and the outcome of that decision, my understanding is that as long as detailed records are kept, that is allowed.
Okay, so that doesn't answer my question though.
Okay.
The question was, when somebody followed that system and signed up for your classes and they went through the Pyrex side of it, was the money actually going into your campaign committee account and then being paid back out of it? Or was it going to some other account?
It was going into the campaign account and swept out.
Okay. And was the deposit in and the sweeping out reported anywhere? In the filings with the Board of Elections or the Secretary of State?
Because they were not campaign contributions, they would not be filed with the Secretary of State. Only a contribution or an expenditure with the account would be filed.
Right. So if I looked at the bank account for your campaign account, I would see a deposit in and a payment out. But in terms of the documentation you were filing with the Secretary of State, it would not be reported.
You have that correct.
Okay. Thank you, Mr. Chair.
No, thank you. Any other questions? Mr. Richter?
Yeah, I've got a couple. One in the, and maybe I'm missing something, which is always a possibility. In what the Secretary's office in their referral list is the second, third, and fourth referrals. It talks about Facebook advertisement library is paid for by the Friends to Elect Dino Vitale, and it lists 3 different items for an amount to be paid that I believe it's saying weren't reflected in the campaign finance reports. And if you responded somehow in your response to that, and I'm missing it, I apologize, but I'm just trying to understand what that means, what they're reflecting in that. And then did you list those? Did you miss out on those? Are they there and I'm missing it? I'm confused, I guess, is what it comes to.
Okay, I'm looking at that as well on the original complaint form, and you're talking about point 1 that says video, point 2 that says video, point 3 that says video. Is that what you're referring to? Okay. Yeah. So the first thing I'd note is on all 3, they state in an amount under $100, but they don't state what the amount is. So I was a little confused at what they were pointing to because there's no specific amount given. And then they say for 3,000 to 4,000 impressions, or for 1,000 to 2,000, or 4,000 to 5,000. Again, those numbers are very wide ranging and non-detailed and non-specific. So there were no videos done that were produced or anything for the class. There were no expenses that were put into place for any videos. We have shown videos on both my personal and the campaign, or the political, if you will, a public Facebook page of some of the classes. And that's something we've done over the years, but it is not something we paid anyone to do. It was literally just shot with a cell phone and posted to social media sites.
Okay, so then presumably there was not an expenditure that you could identify that went along with those items that they reflected.
That's correct. They were just shot with cell phones on our range, and we just posted them.
Okay. The other question I have, and it kind of dovetails to what Ms. Cunningham was asking about, and I appreciate what you may have occurred as it relates to the Secretary's office in the past, and you know, that's in the past. The statutes require any candidate to have a campaign fund that is separate and distinct from their personal or business accounts, from their business funds. And if I think I heard what said is there have been times when monies for the CCW case events have gone into your into your campaign fund. Is that correct? Have there also been any other opportunity or times when funds that should have gone into the campaign fund went into your personal or business fund?
Okay, on the second, it's never. There have never been any times when anything meant for the campaign, either contribution or expenditure wise, has gone elsewhere. Secondarily, the campaign funds, I was told you can use that Pyrex system if you keep detailed records and make sure that they're not commingled with any campaign expenses. And so that's what was done.
Can you
That
give
is
me
sound.
an understand?
Sure.
Can you give me an understanding of how many times that funds would have come in for what you're classifying as your CCW through Pyrex are going into your campaign account and then getting, as you quoted it, swept out?
Probably 60, 70 students would have used that service.
So between 60 and 70 times you've had funds that have gone into your campaign account. You understand that when money goes into your campaign account, those are campaign funds, correct?
They are, I was told that they are only considered campaign funds if they are listed as contributions or expenditures. And since they were being swept out and detailed records were being kept, that is not against the law. And again, a case was cited to me where this was done prior and was brought to this commission. It's probably been 20 years now where the same sort of thing was done. So
I just want to make sure I'm clear. I understand this. Between 60, how much do the concealed carry classes cost?
we charge 100 for those.
Okay, and so somewhere between 60 and 70 times, we've had $100 that has gone into your account, which is your campaign account, and you're removing that money from the account, and there's no record of it getting reported with anybody other than you're keeping a detailed record. Is that fair?
And yes, and with my tax accountant, of course, if there's any income to be made, but there's usually no income on these because of payment to instructors and rental and those sorts of things that we have and insurance costs.
But you're not notifying the Board of Election that you are taking money out of your campaign account on these 60 to 70 occasions to the tune of $100 on each occasion. Is that accurate?
Yeah, I would liken it to the fact that sometimes a candidate and or a representative or senator gets in their car and drives to an event and then goes back home, and that was use of gas in their vehicle, but that's not reported. I mean, there are several times when things are actually used for the campaign that are not reported. And in this case, none of this was used for the campaign. This was simply using the electronic mechanism and then diverting the funds right back out.
Well, the problem I have with it, sir, is once it gets into the campaign account, those are campaign funds. Those are not Nino Vitale or CCW or any other funds. Those become part of the campaign. And once they're in the campaign account, you are responsible to report that as campaign activity.
I do not believe that's true of the law.
Mr. Richter, am I stating that incorrectly?
Yeah, I'm not sure, in your materials, you reference an old NRA case, and I'm looking back in my database and I see two cases in the 90s for which I don't have easily available information, and one case in 2002, but it dealt with a PAC and the way the PAC took in potentially in funds or the way. And so, yeah, I mean, you may have gotten some bad information, Mr. Vitale, but the statutes obligate a candidate, and we just had a long case that the commission has been going back and forth on over the last month involving use of personal funds. And I'm not saying that that's what you did, but involved in that was, an identification in the statutes that a campaign committee is obligated to keep its campaign fund separate and distinct from a personal or business account. And if you're allowing funds to be moved into that account, I don't think that's proper. And it may have been something that you were able to do, and somewhere in the past it was, approved, as it were. I appreciate that, but that isn't a strict separation of the funds, of the personal and business and the campaign fund, that I believe the statutes obligate any candidate, any PAC, whatever, to have. Because when I look back in our database, and again, there were 2 NRA Victory Fund cases that the commission decided in 91 and 93. I've been around a long time. I might have been around for the 93 case. But I'm not recalling it. I can look up and see what the statute is. But the 2002 case reflected, in the 2002 case, the commission found a violation of the statute in that case, and it was 3517-082, which is not something that a candidate deals with, such as yourself. That deals with a PAC and how a PAC is obligated to keep its, who it can solicit, how it gets its funds, where the funds come from, how the funds are treated. And in that case, we found that there was a violation in the case. So I'm not sure, if anything in the other NRA case you're speaking of indicated that, but that's also, the NRA is a PAC separate and distinct from a candidate campaign committee, where there are, I think, specific obligations to keep separate campaign funds from personal and/or business funds.
Yeah, if I might make a comment.
Sure, go ahead.
These were, as I stated, I've been a concealed carry instructor for prior than I was a state rep. And these were all issues I've gone over with ethics and with the Secretary of State for the better part of 7 years. And it's troubling to me. And I know that, it's a difficult situation, because had they initially, any of these people said initially, you know what, all you need to do